Her sad story is she has 3 kids. The husband left her. She sold a car, bought the land, and now she doesn't even have a quarter of that land where she will lay her head.
Litigations leading to violent clashes. Land issues in Ghana over the past few years have taken a different turn. In the Greater Accra municipality, it is worse, with multiple sales of land and other forms of litigations. Today, we are in Amomole in the GhanaWeb municipality, where several landowners are on the verge of losing their lands to incidents of multiple land sales. We speak to them today on Say It Loud. My name is George AC. We'll be right back. Welcome back from the break. Today we are in the GhanaWeb municipality, Amomole to be precise, and I'm joined by 3 gentlemen who have lost their lands or are on the verge of losing their lands to this issue of multiple land sales. I have joining me Mr.
Edward Dante.
And then say your name.
Reverend Jonathan Upon.
Your name, sir.
William.
Welcome to Say It Loud on GhanaWeb TV, and we would like to start off with how we got here in each of your situation. Mr. Edward, please tell us, how did you get into this situation?
Actually, for some time now, okay, I received a call from one of my caretakers. I actually had a poultry farm on this said land that we are disputing on. I had a poultry farm, I had 2 structures, buildings, I had a fish pond. Then I also had 2 containers erected right in front of the land. But the land was purchased by one of my brothers, that is Mr. William Odoi, who is also here. Okay, and we've been farming on the land, we've been doing poultry. I had a call from my caretaker that one Mr. Oshipi, Oshipi came with some group of people to pick the land. I confronted him and he was like, they've given the land to somebody. Meanwhile, they are the same people who gave us the land. When I say they are the same people, we bought the land from a chief, but because a chief don't move to lands, okay, to show you where you are, he has his boys on the land. Okay, so they are the same people we met and they gave us the place. We actually bought 2 plots, and when we weren't available, they actually sold one and called and told us they were going to do a replacement. That hasn't come, and this is the second time they come to take the second land which we are operating on. So I confronted him and they left. I had a call again a few days later, and I came back to meet him, that same Mr. Oshipi, with another person, and I tried to explain to whoever that person was that the place belonged to me. Okay, and on the 3rd time there was a different group who told me they actually heard there's a land for sale there and they've come to check. Then later I realized they called me. I gave my number to them. I made them understand it's for me. They called me back and told me that the one who actually wants to buy the land, okay, from Oshipi, that group, is on the land. Okay. So I was happy to go meet him.
Not to cut you off, but because of time, we need to brief about it. So the issue is you bought your land from some people. Yes. Who are which jurisdiction are they from?
They are from the Ablikuma
traditional council.
Yeah, the traditional palace. That is Nilabi Mensah's palace. Okay. But unfortunately, Nilabi Mensah is dead now, and after his death, that is when this issue started. Okay.
But do you have documentations on this land?
Yes, we have everything, and it's even under registration. Okay, that's the level we are now. It's even under registration.
Okay. Yeah. So what has happened to the land now? Like you said, they have come to
they came to demolish everything we had on the land. So we reported the issue to the police station, and the police hasn't taken any action. Talking of the Amasamai police station.
We'll come to the police bits, but what is happening on the land at this moment?
They are building. They erected a wall, and they come there on Sundays to build. Okay, we've tackled every jurisdiction we have to go to for things to be brought to book, but they are still, as I speak to you now, they are there building.
Okay, then let me speak to Reverend and find out his situation. Reverend, how about you? How did you get here?
Okay, as I said, my name is Reverend Jonathan Opong of the United Pentecostal Church. Amomole is one of the branch churches of the United Pentecostal Church in Ghana here, and I happen to be the branch pastor. Around April, we were there and we realized I had a call that some people have broke through our wall and they've entered in and they are walking around. So what happened was I had to call one of my deacons to find out what was going on. So he went there and happened that truly what I heard was true. They've broken the wall and they have come to pick, that is, one plot out of the whole land, and they've started erecting wall. So we sent the matter to Pokwasi police station, and we had the soldiers coming in to stop them. After which then we realized that they are still what we call constructing. Recently we realized they have now building what we call security post. When they came, we had a structure on the land. They have cleared out the structure and also broke through. But I also believe, Ranton, that according to Ghana law, if somebody be on the land for at least 12 years, you have no right to come and just break through and come and take possession. So I am appealing to authorities to help us in that direction to get us back our land.
Okay. Talking about appealing to authorities, we know this is Amomole and there's a chief here. We will speak to you about how far you've gotten to in getting your issues addressed. But let me speak to Mr. Willie as well. Mr. Willie, how has this whole issue of multiple land sales and land grabbing essentially, how has it affected you?
Like he complained, I'm going through the same thing. As we speak, they are on my land. Now as we sit, they are on my land. A land I purchased way back in, I think, 2002. Way back, and occupied till now. Somebody has come, cleared everything on the land, and is developing. I wonder, this is our country, Ghana. What is going on? It's been reported to the police. The police are in the know. They have done nothing. And I just wonder how our country is going. What is going on? Somebody just wakes up and breaks into somebody's, like he complained, a church. They go there, they break the wall. And I wonder what is happening to our country. Come on. Let's wake up. We are Ghanaians. Let's just wake up. I am suffering the same thing. My land is being developed by somebody who doesn't have documentation. He hasn't presented anything. He thinks that, yes, this land he must sell. So he sold to somebody and it needs to be developed. And he's developing. I wonder. I mean, well, then if this goes on, then I need to take somebody's land and also develop it. That is what is. We are getting into the animal kingdom. That is what we are getting to now. It's a country with constitution. Come on, let's wake up. And you see, there are people sitting down and watching this go on because it is not them. So yes, it is fine. They should move on.
Okay. You talk about the fact that there's a constitution and there's a law. So we'll speak about how you've tried to get these issues resolved. Pastor, how about for you, how have you tried to get this issue resolved using the law?
Okay, as a matter of fact, when the matter happened, we came to see the chief, Ni Komi, and he's working around the clock to help the situation.
But for now, are you able to go to the land, Mr. Willie? I'll ask you, are you able to access the land? Because, I mean, we've come and you are talking about land. Ordinarily, we would have to go and see the land. But are you able to go to the land?
No. The authority that has taken over the land, that authority is ruling the land. That is the only problem. I have a land, I have my documentation, and I can't go to the land.
So right now, as we sit here, if you get up right now and you say you are going to the land, what do you expect to happen?
We can go there so the cameras can record. You can see what happens there. I have reported to the central. I have gone to the headquarters. I have reported to Amasaman, to Pokwase, and then the police station. Where's the place? Yes, the police station there. There's a police station almost close to the land. I have reported there. I have done all that is needed to do when you talk about authority. Nobody seems to be able to do nothing. Somebody has woken up. He calls himself Ushipi. I wonder which Ushipi it is, and I wonder which chief is carrying that Ushipi as his lord. I wonder. He wakes up and has authority to take somebody's land and sell. And they are chiefs in Ghana.
Okay, that's Mr. Willie. But Zanti, for you getting this issue resolved, or even before we come to that, how much is this costing you in terms of finance, in terms of drain on your stress and all that? How much is this costing you?
I wouldn't quote anything less than 800,000 cedis. Yeah, because comparing what we did then, the amount we used then to today, it will even be over that. When you wake up in the morning, you are just so traumatized to the extent that you can't find your way around anything you're doing. You get it? You have to go to the police station. You have to be thinking of who to speak to, who is going to listen to you, who is going to move with you, and it's all finance. I'll be honest, what I'm saying. It's just weighing me down. That's the honest truth. It's just weighing me down.
Let me ask Reverend, for you as a man of God, you preach peace, and obviously this kind of things goes way contrary to the peace that you preach. Looking at how the issue of land sales and land dispute is growing in this country, what do you envisage is going to happen in the future if, as a country, we are not able to deal with this matter?
As a country, if we don't deal with this matter properly, then very soon we are going to end up into the animal kingdom, where anybody that has strength can just pounce on anybody. Then obviously there's going to be war. Why? Now, if I come for your land and you also think you have a way to come for somebody's land, then it begins to move that way. Then there's not going to be peace among us. And when there is no peace, there can't be development. Then obviously the country is shifting into another third world war. And obviously this will not be a very good place for us to live. And that is why when it happened, I told my members they should hold on. Let's take it through the appropriate channel. We could have done same by going to break it down, but then I believe in peace, and that is why today we've waited to this time for you coming in to hear us.
I asked Mr. Edward about how it is affecting him in terms of finances and all that. How is this issue affecting you and your church?
Same. As a matter of fact, people believe church has money, but it's not all church. We have money though, but then if money is to be raised, envisaging we are doing project and thing, and later on for something to happen and now you are channeling your money in fighting something you already have, obviously it looks like you are going back. You cannot make progress in ministry. So this is affecting the church, myself, and the organization as a whole.
So Willie, you are at a point where you feel like your land is almost lost. How far are you willing to go to get back your land?
I wish I could answer this. I have already explored every available service, because I have gone to every other police station, reported. I have done it all, accused everybody, visited every chief's palace, done every of the press conferences, done, and one OCP has that authority. I just wonder. Expenses, I don't even want to go there. Will you spend as much as everything, and still OCP is standing on the land? He is authority. He doesn't respect anything. He doesn't see anybody. Please, this is our country. I would just plead with everybody else. If we say we have a law, let it work. Let the law just work. Let's all respect ourselves and do the right thing. Because if we don't do that, today it is me. You don't know about you tomorrow. Because if you also talk about this and it doesn't work, then it means that somebody can do it to you. And we should just then be ready. Because somebody is also watching and will do the same thing to the next person. Me, if somebody does it to me and nothing is done, I am ready. I would also do it to somebody. I will do it to somebody. Yes.
We are wrapping up. So, if you are to say your last words, what would be your last words?
Okay, honestly, I'll begin this way as I sit now. That's what is running into my mind, to also organize myself, get some group of people who knows the story, I mean some macho men, and also come to the land and, you know, battle up with them. Okay, that is what is running through my mind now, because the pain is too much. I don't even sleep. Talking to my people, I'll just call on the government. I mean the security administration. Make them understand that this is what is happening in Amomole, Canada Junction. And I'm not the only person. You know, a lot of people in the area knows me to be a broadcast journalist. And when this issue started, I've had more than 20 people walking to my house to tell me, so what am I doing about it? Am I not organizing a press conference? Am I not saying anything about it? You get it?
All these 20 people you are talking about have also suffered this.
Yes. Somebody, I can testify of a woman. More than that woman. It's about 25 people. But with this woman, her sad stories, she has 3 kids. The husband left her. She sold a car, bought the land, and now she doesn't even have a quarter of that land where she will lay her head. I have their contacts. There's another sad story of another lady whose husband sent money. They bought 2 plots, built on one and using one for farming just in front of the house. They came and walled it. You understand? And I can go on and on. There is this man who bought it around 2009 that way. Filled this land, it was a valley, filled it, bought 2,000 blocks on the land, fenced it, and now it's been broken into and they are developing. And he has also gone to the police station just as we've done. You see? So they resorted to coming to see me so we could organize a press conference against these people. We've gone wherever we have to go. So it's more like somebody just taking you for a ride. Okay? Some of us are also coming from places. But just that because we respect the law, we are mute. But as I speak to you now, that is what is running through my mind.
So the issue of land grabbing, multiple land sales is happening, and here in Amomole, in the Ghanaian municipality, this is the situation for a lot of land owners here who are almost about losing their lands. They allege that this is being undertaken by some people from the Ablekuma Traditional Council. But then we are going to try to find out from the custodian of the land here, the chief of Amomole, Nikome himself, why this is happening under his watch. We'll be right back after this break. Welcome back from the break. The show is still Say Loud on GhanaWeb TV with me, George AEC. I am currently in the palace of Amomole, the Amomole chief, Ni Komi II, and I speak to him about the concerns raised by some of these landowners and residents of his jurisdiction. Ni, welcome.
Thank you, my lord.
I would first of all begin with a very sensitive question. Do you do double land sales as the chief of Amomole?
Not at all, and I really don't like doing such things. Yes.
Has the situation of some people in your jurisdiction being pushed away or being evicted from their lands come to your attention?
Yes, that is the problem at stake now. Land being acquired by dwellers way back since in the 19-something or that has now been reselling by some group of people claiming they come from Ablekuma. But meanwhile, this place is called Amomole. And as Ghana people, we know where our clans are from. So I knew that I come from an Asane, and where I am is an Asane land. So I'm wondering why the Ablekuma people who are not part of the Asanes but are Sempe people will come to Amomole Ayawaso to come and claim land that it belongs to them. Meanwhile, they knew that the land does not fall in their jurisdiction at all. So this has brought so many disturbances within the area, and we as a people, we cannot take the law into our hands. So we took some of these people to court, and the court is yet to determine or adjudicate upon the case. But we filed an injunction so that there will be peace in the neighborhood. After the case is done, then whoever wins the verdict will go for his land. But these people are going around, entering into people's house, churches, and industries to retake their land, especially the churches. You know, they don't work on weekdays. So when the people see that a certain church is here, there's a portion of land lying by the church, and Mondays the church people doesn't come to church, then they enter and then they start working on it. You report this to the police and everywhere, but nothing will be done about it. And as I knew that matters are in a court, I must wait for the verdict of the court. But as I'm saying, what they are doing is very, very risky, because somebody who doesn't have the heart to wait till the verdict of the court and you have entered into his house, he might end up bringing violence and killing people and all that. And we knew that these people, they know the land doesn't belong to them, so they have prepared themselves with their arms and all that. In the night, they will start shooting all over this town and then be working on a certain lands, so that will deter anybody from coming to question them about whatever they are doing.
You are a traditional leader. You are part of the Greater Accra Traditional Council. For years now, if I'm not wrong, the Greater Accra municipality or region has become notoriously known for these issues of double land sales and all that. How did we get here?
In fact, the poverty in Africa is affecting our brains and our everything. That because of somebody's deliberate, something that is not lawful, is not right, he will go and do it. Because as I'm saying, they sell the lands to other people, and those other people, they too, they have eyes to see that somebody's house is lying on the land, but yet still they still buy. You go there and stop them with the police, they will show them every document that where you are working is for somebody, but still the person will continue to work. So I don't only blame the chiefs, but I blame the buyers too, because you have to make your feasibility search on the land before you acquire it. If not, after somebody confronts you on your land, you must be careful to find out what is the matter? But people in their mind, oh, I have to be strong, I have to be strong. Oh, then they are doing it. If I ask my people to go and stop them right now, they might end up killing somebody, and that they will mention my town's name and my name. So with that, I plead with the state authorities, with the stakeholders, with our police and national securities to intervene into these matters. Always when something is going on in Ghana, people want disaster to happen before they take it serious. We've been writing petitions and petitions to the police, to the higher police headquarters, to everywhere, but nothing has been done about this very issue, and we can't take the law into our hands. But we know that Ghana law works unless they don't want to. Either than that, the land guards are not stronger than the police. The land guards are not equipped than the police. But you go to the police and later you see nothing going on. So we are worried. In fact, we are worried. Me as a chief, moving from my house to town, I have to be careful because there are some people around aiming to kill me, thinking that after I die, they can be able to take the land because I have taken them to court. And all this, we don't have to wait till something happen before we intervene. So I am pleading to the leaders of this country to do something about this our issue.
So for Ni Komi II of Amamole, he awaits the verdict which comes in 2 days and hopes that that will bring an end to the continuous issue of double land sales that some residents in his jurisdiction are suffering. But then all across the capital of the country and some parts of the country, this is a very an issue that has become very rampant, and it is hoped that authorities will step in and make sure that the right things and the right laws are applied. This has been another episode of Say Loud on GhanaWeb TV with me, George AC, and until we meet for our next episode, it's bye for now.
Swear by the Almighty God that the evidence I shall give before this committee touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
My Lord Justice Akayesu, on behalf of the committee, I congratulate you on your knowledge to be promoted to the bench of the Supreme Court of Ghana. You're already a member of the Superior Court, but you're going to the highest part of the Superior Court. Our duty here is to determine your suitability and your qualification for the position. Now, let's start by telling us about yourself.
Thank you, Honorable Chair, and good morning, Honorable Chair and members. My name is Barbara Frances Akayensu. I am a mother of 5, 4 men and 1 woman. I come from a family of 8 children, and I am the oldest. I am a Christian, specifically a Roman Catholic. And for relaxation, I enjoy cooking, listening to music, dancing, traveling, and reading. Regarding my educational background, after my secondary school education at Wesley Girls High School, I gained admission to the University of Ghana in 1974. I obtained an honors degree in psychology and sociology in 1977. I went back to the University of Ghana in January 1979 to read law. I obtained a qualifying certificate in law, which at the time was the qualification required for entry to the Ghana School of Law if you already had a first degree. I gained admission to the Ghana School of Law in September 1979 and was called to the bar in 1981. In 2010, I obtained an executive master's degree in business administration. In 2016, I obtained, my EMBA was from the China-Europe International Business School. In 2016, I obtained a certificate in international commercial arbitration from the Chartered Institute of Arbitrators in the United Kingdom after participating in a course at the Queen's College, Oxford University in the United Kingdom. Regarding my work experience, I did my national service with the Ghana Reinsurance Organization in 1979. After I was called to the bar, I had a short stint at Lyons Kwasi-Aiden and Company, a private law firm. Between 1982 and 2000, I worked with various organizations in Ghana, namely the National Investment Bank, the Non-Performing Assets Recovery Trust, Ghanaian Australian Goldfields, and Ashanti Goldfields Company Limited. In 2000, I was appointed a World Bank consultant / trust administrator, that is the chief executive officer of the Non-Performing Assets Recovery Trust in Uganda. I was in this position until 2003 when I returned to Ghana. I was appointed, shortly after my return to Ghana, I was appointed a High Court judge purposely for the Commercial Court. And while the Commercial Court was in the process of being established, I was posted to the High Court Tema. I was in the High Court Tema between 2003 and 2005 when I moved to the Commercial Court in Accra. I was therefore one of the pioneer judges of the commercial court and became the president of the court between 2010 and 2012. In 2010, I was tasked by the then Chief Justice, together with the Justice of the Supreme Court, to help establish the Ghana chapter of the International Association of Women Judges, which we did, and I was elected the first president of the association. In 2010, I was appointed a guest/part-time lecturer in alternative dispute resolution at the Ghana School of Law. I have co-authored a book on alternative dispute resolution entitled Alternative Dispute Resolution, the Ghanaian Perspective.
Chairman, just there, you have co-authored.
Yes, please.
Who is the other co-author, just for the record?
Yes, the book was authored by myself and a colleague High Court judge by name Justice Dennis Ajay.
That's very important for our record. Did you say pioneer at the commercial court?
Yes, please.
Any memories of pioneer judgment? Any memories of any pioneer judgment, historic and monumental, as you may recall, that your name wants to work with as a pioneer judge at the commercial court? Chairman.
Honorable Chairman, there's so many judgments that I wrote in the commercial court.
Share one exciting, one disappointing with us for our record. Any exciting judgment that you can recall, that one that you are very, very proud of, and one that when you went back to your pillow, you wish that time was reversed. Thank you, Chair.
Mr. Chairman, I put so much industry in every judgment that I write, and therefore I can say that I'm very proud of every judgment that I delivered in the commercial court. As I'm sitting here, I cannot readily think of any particular one.
Chairman, I know your attitude will be to allow our colleagues to come in. No, but I'm just picking something. In your CV, you say EMBA.
That's right.
What's that?
Master's
Why, I
degree.
don't want to say it for him. Thank you. EM.
It's Executive Master's Degree in Business Administration.
All right, thank you. For our record, Chairman, she can continue. I just wanted to satisfy myself that EMBA didn't mean some basketball team somewhere for the Inland. Thank you.
Very well. So I have talked about my experience with the International Association of Women Judges. I am currently a member of the Governing Council of the University of Ghana. And this morning, I am before this honorable committee to be considered as a nominee for appointment to the Supreme Court of our great nation. Thank you.
Chairman, Supreme Court, highest court of the land. How many more years do you have to serve the Republic if you get approved?
I will have 2.5 years to serve in the Supreme Court.
And Chairman, is it our expectation that you go there with the same industry?
Yes.
That you would give judgment that we can be proud of?
Honorable Chairman, you can expect more of me if you approve.
Okay, my first expectation of you there will be Galamsey. Are you aware of the havoc Galamsey is wreaking on our country, on our environment, on our water bodies? What do you think should be the judicial attitude to fighting Galamsey? Thank you, Chair.
Well, Honorable Chair, if I heard you, you are asking about the judicial attitude, and therefore speaking as a judicial officer, we will determine if any case comes before us on the harmful nature of Galamsey, we will look at the particular circumstances of each case and apply the law and make a determination. But as a proponent of ADR, I think that the exception of environmental matters in the ADR Act probably will have to be looked at again, so that we can try applying ADR mechanisms in resolving.
Chairman, my lord, are you recommending Galamsey as a candidate for ADR resolutions of the causes to our water bodies? Is that what you are suggesting?
To an extent, yes, Honorable Chairman.
Even as we see our water bodies polluted,
there will definitely be legal aspects.
What will ADR do to the resolution of those matters? Thank you, Chair.
ADR will come in between the communities and the perpetrators if they are made to sit together and have a conversation.
Are you familiar with the any community where Galamsey or illegal mining is prevalent?
My lord, unfortunately not. I have not been to any community where Galamsey is taking place.
Have you ever had to adjudicate any matter involving the issues of Galamsey or illegal mining?
Mr. Chair, Honorable Chair, no, I have not.
Very
not
well.
Yet.
Maybe I should allow our colleagues to come in, but just to ask, you are moving naturally from the appeals court to the Supreme Court. Are you aware of growing public concern about dwindling public faith and confidence in our judiciary?
Honorable Chair, I am aware of some loss in trust and confidence, but from where I am sitting as a judicial officer, I can confidently say that it is not true, with all due respect, that generally the population is losing trust, because the number of cases are increasing day by day, which is evidence of the fact that there is still some trust and confidence in the judiciary.
Chairman, just related to that, you see, like you were not there, the Supreme Court rules that don't place value on birth certificate, and we know everywhere in the world that the birth certificate is an important reference document, whether in the US, in the United Kingdom, every other republic. Only Ghana's Supreme Court says that undervalue birth certificate as a measure of identification and as a measure of citizenship. Does that help public faith and confidence in this important institution?
Honorable Chairman, unfortunately, I am not able to comment on this, it being a live issue. If I heard you right, Honorable Member, you referred to the fact that the Supreme Court has made a decision. As a judicial officer, I am bound by that decision.
Well, are you conversant with that particular decision? Have you read it?
I have not read it, but I know a little about it.
Very well. So, are you not permitted by law to have a critique? Are you not permitted by the to critique a judgment of the Superior Court?
Honorable Chair, I cannot critique, as I'm sitting here, a decision of the Supreme Court. The only time, if by your, if you confirm my appointment, there is the jurisdiction, the review jurisdiction, and if there is a review application before the Supreme Court, and I am by your confirmation there and I'm empaneled, then I would have an opportunity to make an input.
Yes. Yes, Nilante.
Good morning.
Good morning.
Am I permitted to start with, since I'm seeing my brother sitting behind you, an old player of Vipers, so when I see the Vipers people behind you, but are you a Viper yourself?
Yes, I am.
Oh, okay. That's good. Then the Busian people will not be happy with you. But I want to follow up with the question asked by my leader on the issue of integrity. Before coming here, how do you gauge public perception about the judiciary today?
Honorable Chair, it is a fact that there is some dissatisfaction with the judiciary amongst the citizenry. Some of it for good reason, probably not for so good reason. With the volume of cases that are placed before the courts today, there are delays that people are not happy about. There have been some allegations also about impropriety and corruption, which people are not happy about. But as I said earlier, I think the majority of Ghanaians, in spite of all this, still have confidence in the judiciary. Thank you.
As a follow-up, in your experience, professional experience, have you ever given a judgment and you've gone back home, reflected on it, or Aqua Chapel, na software catcher out there, easy and can ye? I will translate it, don't worry. To it, that you went to church and your church pastor called you and said, Madam, your lordship, this case you judged, your decision was not right. Has it ever occurred?
Mr. Chair, I have never had any such experience. That is not to say that all my judgments are perfect or none of my judgments have been reversed. But at the industry, I put in writing my judgments. At the end of each judgment, I satisfy myself that I have done the best I possibly can.
My leader asks about ADR, and you related it to the issue of illegal mining, and I'm saying one of the most difficult areas for ADR resolutions as far as the adjudicating cases concerned is the issue of land litigation. You come from a region where these land litigation issues are so high. What do you think we can do, and as much as possible, to sensitize people to avoid the traditional litigation and move into areas of ADR in order to settle some of these protracted cases involving traditional areas, and especially in your region?
Honorable Chair, my short answer would be education, education, education. I think we have to increase the awareness of people about ADR and its benefits as opposed to litigation. The fact that it is efficient, it is faster, relatively cheaper, and more importantly, at the end of the day, the parties themselves are the ones who take the decision. And I think that if people are made to know about these advantages, and also the fact that the courts will enforce a final agreement reached by the parties, it will help. Thank you.
Thank you very much, Chair. Congratulations, my lady.
Thank you.
My lady, I'm referring to your judgment before me, Civil Appeal Number H197/2019, B.F. Akayensu presiding. The matter between International Rum Limited, where the appellant, plaintiff respondent appellant, versus Vodafone Ghana Limited as the defendant applicant respondent, and Fidelity Bank Limited. You wrote the lead judgment of the court in that matter. I have time to read the judgment and the award therein. What is the mark of a good judge? Thank you.
In my opinion, sorry, Honorable Chair, in my opinion, the mark of a good judge can be put into two groups. The first is competence or knowledge of the law. As the saying goes, the law resides in the bosom of the judge. In saying this, I am not saying that a judge should have all the law, everything on his or her fingertips. I recollect a lecturer at the Ghana School of Law telling us that to be a good judge, you don't have to know everything. You just have to know where to refer. The second group of qualities that I would talk about would be judicial comportment. Judicial comportment, which includes patience, humility, and courage. But for me, the most important qualities are integrity, fairness, and reticence. Thank you.
Sorry, what was the last one?
Reticence.
Reticence.
Yes, please.
Chairman, just Patrick, did you say the law is in the bosom of the judge? We heard you that right, Chairman. Did we hear that?
Honorable Chairman, yes, I
and then subsequently, Chairman, did we hear Nominee her ladyship saying that sometimes no longer in the bosom, but what you can refer to? Is that right?
Yes, at the end of, yes, Honorable Chairman, at the end of the day, whether you have it on your fingertips or you have to refer, the law still resides in the bosom of the judge.
Except sometimes it is not in the bosom or at anywhere of his or her body.
Thank you very much. My lady, may I refer you to your CV, page 5. Yes, on top, leadership positions held is numbered from there. Member of the committee for the impeachment of Justice Ringo Kas Azuma for misconduct 2016. Member of committee for the impeachment of Justice Fred Kwesi for misconduct 2019. Looks like the judiciary itself has had challenges with some of its members. What are some of the issues that you've been able to deal with to correct some of the things that that has come before you with regards to some of the committees that you've sat on? Thank you.
Well, Honorable Chair, the judiciary being a human institution is bound to have challenges with the human beings who work for the judiciary. And so, yes, there have been challenges. And fortunately for us, we have provision for addressing these challenges. The Constitution itself provides a procedure that if any member of the public has any problem with a judge, there is the avenue of petitioning to the Chief Justice. The judiciary itself also has a complaints unit that deals with complaints about judges. So, in short, the judiciary is regulating itself to deal with these human challenges.
Thank you very much, Chairman. My last question is on the Constitution. The Supreme Court has about 6 or 7 jurisdictions, original, supervisory, review, decisions from the House of Chiefs, National House of Chiefs, and the rest. In your view, humbly, do you think the jurisdiction of the Supreme Court is too wide and has to be narrowed because of the workload with regards to some of these appeals and jurisdictions that have been conferred on it by the Supreme Court to allow it to perform some limited functions? Thank you.
Thank you, Mr. Chair. Yes, the Supreme Court of Ghana has a wide variety of jurisdictions that it exercises. I think there are even more than the 6 that you listed. And that is one of the reasons why the workload at the Supreme Court is as huge as it is. In fact, Ghana is quite peculiar when it comes to the variety of jurisdictions exercised by the Supreme Court. Not even in the United States, not even in the United Kingdom, not in Canada, not in Australia, not even next door, Nigeria, do the Supreme Courts of these countries have as wide a jurisdiction as we do. Mr. Chairman, I dare to say that that is one of the reasons that we have the numbers that we do in the Supreme Court, because of the variety of jurisdictions exercised, which results in a huge workload. Thank you.
Chairman, okay, Chairman himself. No, after you, sir.
Yes. Are you referring to Article 1291? Let me read it and point out where you think it's different from the countries you've mentioned, countries, other Commonwealth jurisdictions. 1291. The Supreme Court shall be the final court of appeal and shall have such appellate and other jurisdictions as may be conferred on it by the Constitution or by any other law. So, jurisdiction, all right, so I'll go to 130. original jurisdiction of the Supreme Court. The subject to the jurisdiction of the High Court in the enforcement of fundamental human rights as provided in Article 33 of the Constitution. The Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution. B. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law under this Constitution. 2. Where an issue that relates to a matter of question referred to in Clause 1 of this article arises in any proceedings in any court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court, and the court in which the question arose shall dispose of the case in accordance with the Supreme Court decision of the Supreme Court. And then you come to 132, supervisory jurisdiction. 133, review jurisdiction. Are these the matters you are referring to, the wide jurisdictions you are referring to? Are there any more?
Yes. Thank you, Honorable Chair. Yes, these are only some of the jurisdictions exercised by the Supreme Court of Ghana. On top of the ones that you have listed, we have other jurisdictions like appeals from the National Council, House of Chiefs. We have exclusive jurisdiction when there are challenges in presidential elections. We have the jurisdiction for production of official documents that may impact on security. We have the jurisdiction to award compensation if somebody has been charged and later on acquitted. The person can apply for compensation and it goes to the Supreme Court. So there are about 9 jurisdictions exercised by the Supreme Court of Ghana.
How is that different from other Commonwealth jurisdictions?
My Lord, if you permit me, I have some data. So, for instance, in the Supreme Court of Australia, it's basically appellate and original, just these 2 jurisdictions for Australia.
And Chairman, you are suggesting that in Australia they have no interpretive role? They don't interpret the Constitution there? Thank you.
As far as my research goes,
for the record, appellate and...
That was why I premised it by, as far as...
Appellate and original.
Appellate and original.
All right, thanks, it's noted.
Then United Kingdom, the Supreme Court of the United Kingdom is primarily an appellate court. And it hears appeals. Thank you. It hears appeals from the UK's 3 distinct legal systems, England, Wales, and Scotland, and Northern Ireland. In Canada, the Supreme Court's jurisdiction is principally that of a final court of appeal, apart from the jurisdiction to give opinions on questions referred to it by the government. In Nigeria, the Supreme Court of Nigeria is also primarily an appellate court, although it has original jurisdiction in relation to disputes between the Federation and the states and between the states. In Uganda, the Supreme Court is not even the Constitutional Court. The Constitutional Court is the Court of Appeal.
Very well. Yes. Agaga, then I'll come to you, Honorable Ahi.
Congratulations, my lady.
Thank you.
Let me take you to page 2 of your CV. And here, I'm looking at your qualifications. You indicate that you obtained the qualifying certificate in law between January 1979 and September 1979. It's a period of about 6 months. But it appears people did the same course for about a period of 2 years. How do you respond to the difference in terms of the time frame within which you completed your QCL?
Thank you, Honorable Chair. Yes, in my time, you had an option to either do 2 years on part-time basis or 1 year full-time. But the year that was supposed to have started in September of 1978 started in January 1979 due to student unrest. And that is the reason why we did ours in such a short period. Yes. So it was very intensive.
Your Ladyship, you have been a Court of Appeal judge for a long time. I'm looking at Article 136(5). And the 5 reads as follows: subject to clause 3 of Article 129 of this Constitution, the Court of Appeal shall be bound by its own previous decisions, and all courts lower than the Court of Appeal shall follow the decisions of the Court of Appeal on questions of law. So, in other words, the Court of Appeal under this provision cannot depart from its own previous decisions. Did you ever feel constrained in the course of your work as a Justice of the Court of Appeal in the face of previous bad decisions of that same court?
Mr. Chair, I cannot sit in here, make that determination that any decision of the Court of Appeal is bad. That determination can only be made when it goes on appeal and is reversed. And as the provision you just read indicates, I am bound by decisions of my court. Thank you.
Well, my lady, your CV also indicates that you are one of the pioneer justices of the Commercial Court, and at one point you served as president. In fact, when you were at that court, I think on a number of occasions, I practiced before your court. My lady, the Commercial Court rules makes it mandatory for pre-trial conferences to be held. In a way, you can say there is some form of ADR incorporated into those rules, and it's mandatory. Given the fact that that system allows for the efficient and expeditious administration of justice, would you, by way of law reform, recommend that aside commercial cases, all civil cases should be subject to the same procedure?
Thank you, Mr. Chair. As a staunch supporter of ADR, I would definitely make that recommendation that as far as possible, mandatory ADR should be extended to all courts. It is to make for expeditious determination of cases, and the commercial court is proof of this, that when ADR is applied in the courts, cases generally are determined in a speedier manner. And at the end of the day, the parties go out more satisfied than if the matter had gone through trial. Thank you.
Last question. My lady, this question has already been asked by the ranking member of this committee, who is also the minority leader. But for emphasis, he did say in his opening remarks that there is the perception that the Supreme Court is being deliberately packed for the sake of political expediency. And if you consider the fact that your approval is certainly going to add up to the numbers, so that would be looking at 18 justices of that court, should you be approved, do you think that the approval would feed into that perception that this committee is aiding the packing of the courts by the appointing authority for that same reason?
Mr. Chair, with all due respect, I think that is a misconception. For a start, it is not a fact that there are going to be 18 members of the Supreme Court should you graciously confirm my appointment, my nomination. As a matter of practice, generally speaking, nominations to the Supreme Court are made when there are vacancies. When some of the Supreme Court judges are going on retirement, and as we are speaking here, a number of them have gone on retirement, thus creating vacancies, and hence my nomination. So I cannot agree with all due respect what you have just said about the Supreme Court being packed. And as I earlier on indicated, the workload warrants the numbers that we have. For the longest time, I believe it has been 15. Thank you.
No, you. Tampuli, yes, then I'll come to Black.
Thank you very much, Mr. Chairman. My lady, I congratulate you. Now, coming back to the point that has already been made regarding the jurisdictions of courts, and you have enumerated about 9, jurisdictions. Now, one of the jurisdictions of the court, which is the presidential election petition jurisdiction, is one that I want to bring to your attention. And I'm doing this comparing it with the case of the recent Kenyan presidential election petition, where the petitioner is required under the Constitution, after the declaration of the results, to come within 7 days with the petition, and then serve on the respondent within 2 days. The respondent has 4 days to reply, and then you go through interlocutory matters applications within 8 days. And when the hearing starts, it takes just about 5 days. Petitioners get to make their case, respondents do the next day, then you have replies, rebuttals on the 3rd day. Then the court put Humpty Dumpty together. Then the next Monday, the Supreme Court gives its decision. So it's done in a very quick succession, and this is constitutional based. Now, how is it that we are not able to do something like this? And bear in mind that we have parliamentary election petitions from the 2020 elections still ongoing. Not even presidential. Presidential we are done, but we are still, haggling with the parliamentary election petition at the high courts. Can we do something like that? Thank you.
Thank you, Mr. Chair. I believe that you made reference to the Kenya situation, and I believe it is a matter of, these are statutory requirements, and nothing stops us from enacting a statute that will indicate the procedures to be adopted for election petitions. Thank you.
Thank you, Mr. Chairman. My lady, I also want to refer you to Article 131. Article 131 1A and B of the 1992 Constitution, the appellate jurisdiction of the Supreme Court. Now, in terms of the petition, election petition for parliamentary elections, the matter terminates at the Court of Appeal. You do not have a right to go to the Supreme Court, and it is said in the Nimakan case that is established, judicial precedents. Now, is it possible to also go by way of enactment so that not every appeal should go as of right? And with your permission, Mr. Chairman, I'd like to read. Article 1311 says, an appeal shall lie from a judgment of the Court of Appeal to the Supreme Courts. A, as of right, in a civil or criminal cause or matter in respect of which an appeal has been brought to the Court of Appeal from a judgment of the High Court or a regional tribunal in the exercise of its original jurisdiction. Now B, it says that with the leave of the Court of Appeal, in any other cause or matter where the case was commenced in the courts lower than the High Court or a regional tribunal, and where the Court of Appeal is satisfied that the case involves a substantial question of law or is in the public interest. Now, how is it that with the jurisdictions that you have given, Nigeria, Australia, the UK, and the US, they have the appellate level of matters, and then we just do it a free for all, and then we go and say that the court is being packed. Meanwhile, these courts are packed by humans. They can't do all these cases, by themselves, but so we have to do different panels that will be listening to different cases. I believe people want to see us have a 9-member panel, but you can't give a 9-member panel these 9 jurisdictions. What's your take on us amending the Constitution, for instance, and to limit the jurisdiction, the appellate jurisdiction in some matters, just like we have done for the High Courts in terms of parliamentary election petitions? Thank you, Mr. Chairman.
Mr. Chair, I think the issue of cases going to the Supreme Court as of right is one of the issues that should be taken into consideration in looking at the numbers in the Supreme Court, because it is not in every jurisdiction that the cases go to the Supreme Court as of right. And if I may be permitted again, in the Supreme Court of the United Kingdom, the Supreme Court, they choose the cases, the Supreme Court chooses cases it wants to hear. And nearly all the appeals need permission of the court below, which is not frequently granted, or the Supreme Court itself. In the United States, they have a set of petitions, and it is not automatic for anybody who loses a case in the Court of Appeal to go to the Supreme Court. 4 out of the 9 members have to agree that a matter be heard in the Supreme Court before the Supreme Court of the United States will hear a case. I recently read an article in the U.S. Guardian which stated that the United States Supreme Court hears 70 cases a year. I can give you statistics of the number of cases that go before our Supreme Court. My Lord, with your kind permission, in 2021, just for the supervisory jurisdiction, the Supreme Court of Ghana received 354 cases just for supervisory, and disposed of 420. This year, 2022, it is not any different. And therefore, the fact that cases go to the Supreme Court as of right poses a challenge to us. Thank you.
Chairman, just there. But as of right, a constitutional imperative, we didn't put it there. The Constitution says as of right.
Yes.
You have a difficulty with that? Are you advocating a constitutional amendment to Article 131? Is that what you are suggesting, for the deletion of the words as of right? Is that what you are suggesting?
Honorable Chair, it is not in my place to make that suggestion. I am only saying that that is the law as of now, and also bringing to your attention the difficulties that the Supreme Court faces as a result of the law. It is up to the people of Ghana, if we feel that there is the need to make changes in the Constitution, for that to be done. Thank you.
My Lord, at this stage, we want your opinion. I have come to you. If I came to you as a legal consultant, and I wanted your opinion on whether or not this as of right should be maintained or we should amend it, what would you be your advice to me?
Mr. Chairman, with all due respect, I cannot be your legal advisor. As a judicial officer, I am bound to follow the Constitution until amended. Thank you.
Chairman, I still have some follow-ups. Honorable Tampula, I hope you tolerate me on your presidential petition and on Article 131. Chairman, with your indulgence, 131 reads, and I quote, "An appeal shall lie from a judgment of the Court of Appeal to the Supreme Court, A, as of right, in a civil or criminal cause or matter in respect of which an appeal has been brought to the Court of Appeal." Your Ladyship, mine is the word as of right. Couldn't 131 just read, "An appeal shall lie from a judgment of the Court of Appeal to the Supreme Court in a civil or criminal court," just exercising appellate jurisdiction without emphasis on the word as of right? That is what Chairman is asking you for your view on this particular provision. Thank you.
Thank you, Mr. Chair. Since I've already indicated that it poses a challenge to the Supreme Court of Ghana, this conversation could be had between stakeholders.
Okay, Chairman, we interpret the answer to mean that she wished that it was not as of right. Sitting here. But Chairman, again to Honorable Tampule's question and your Ladyship. The Honorable Tampule referred to Article 64 of challenging presidential elections outcome. And in your answer, your emphasis was, I paraphrase you, statutory. There I disagree with you. And I'm referring you to Article 64(3) of the 1992 Constitution that if you so qualify, you'll be interpreting. It reads, the Rules of Court Committee shall by constitutional instrument make rules of court for the practice and procedure for petitions to the Supreme Court challenging the election of the president. Emphasis my constitutional mandate and obligation vested in the Supreme Court. I do not agree if your thinking is that it's statutory. So come back to his question. What can Ghana learn? What can Ghana learn from Kenya, guided by the provisions of Article 64 as observed by my colleague? Thank you, Chair.
Thank you, Chair. I believe the law is dynamic. So at every point in time, we should look at the law and whether it is doing what it is meant to do in terms of maintaining law and order. And therefore, if there is a practice in Kenya which would help us in this regard, I do not see anything wrong with us adopting it.
Are you done? Please proceed.
Thank you very much, Mr. Chairman. Now, in the ranking member's opening remarks, he made reference to qualification for appointment to the Supreme Court. And it's natural that when you move from High Court to the Court of Appeal and then Supreme Court, of course, that is not statutory. Now, one of the foremost jurists in this country, one Justice John Nicholas Kobina Taylor, aka J.N.K. Taylor, was promoted from the High Court to the Supreme Court in 1980. It turns out Justice Taylor was one of the best things that happened to the Supreme Court. Now, I'm not sure whether you were taken from the High Court or from the Court of Appeal. It would touch your competence. What do you think about such promotion?
Thank you, Mr. Chair.
Chairman, why? It's Taylor Babra.
No, I think I'll disallow this because you're using her to respond to the minority leader. Let her do the legal things and let the politicians do the politics. So can we ask another question?
Mr. Chairman, you see, we are talking about facts. There are different means through which the president would appoint people to the Supreme Court.
So can you rephrase your question and leave out the minority leader's
straight from the bar? No, I'm not challenging the chairman. I'm just, giving further and better particulars.
I'm ruling that rephrase your question, leave out the reference to the ranking member, please.
So let me take a cue from the chair. A person shall not be qualified under Article 1284. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of a high moral character and proving integrity and is of not less than 15 years standing as a lawyer. Now, if anybody falls within this category of persons and is appointed to the Supreme Court, do you find that lawful and constitutional? Thank you, Mr. Chairman.
Thank you, Chair. Honourable Member, I believe you have referred to a provision of the Constitution which is without the qualification, and that is the position. Thank you.
More questions.
Yes, Honorable here with.
Thank you very much, Mr. Chairman. Mr. Chairman, let me also congratulate.
But you have believed. How can you ask questions?
Oh, that's my mother. So what is the problem?
Let's answer the question.
Let me congratulate my Lord for the appointment to the Supreme Court. And my first question is on legal aid. Legal aid country. We know that a lot of people, and I'm sure in course of your practice as on the bench, the High Court and then the Appeal Court, there were instances where people appear before you without the services of lawyers. And legal aid exists to provide free legal services to such people. I mean the poor and the marginalized in society. But you agree with me that even in Accra where they exist, it is difficult to access their services. Not to talk about where I come from. I mean, they don't even exist at all. From the western of region, we don't even have the services of the legal aid system there at all. They don't exist. What do you think we should do to ensure that we people have access to services by the legal aid so that they can also have justice to whatever they go to court for? That's my first question.
Thank you, Mr. Chair. As much as I am very interested in access to justice for everybody, particularly the vulnerable, I do not think this really is the concern of the judiciary. I think it is the bar that should look at this. Thank you.
Mr. Chairman, the nominee is saying that this doesn't fall in her domain as a judge, but I just want to seek your view on situations where people appear before you and maybe they even lost the case because of lack of the services of. So I just want your view on what do you think we should do so that, because when people appear before you with lawyers, they help you to expedite action on their cases. So it will have direct impact on how quickly you're able to, adjudicate cases. So what do you think we should do?
Honorable Chair, I share the concern of the Honorable Member that it is a sad thing for Ghanaians, especially the vulnerable, not to have access to justice simply because they cannot afford it. So as a society, I think we should encourage access to legal aid. I don't know, I think it is, as I indicated earlier, I think the bar should work on this. Thank you.
The Western North Bar is very depleted. Unfortunately, that's the problem. I'm not sure he will pass the law school soon, and practice there. Yes, Honorable, please continue.
Mr. Chairman, I think all of you must be interested in this question because whether in Accra or in Kumasi, where Muntaka comes from, even a lot of clients struggle to access the services of lawyers. So this, all of us must show concern. So, Mr. Chairman, my next question has to do with the fact that there is a perception in Ghana that our legal systems, Ghana legal system leads to unnecessary delays in adjudicating cases, and also very expensive, very expensive. People who want to seek justice for or whatever. Mr. Chairman, what would a nominee suggest we do to ensure, or can you explain to us what accounts for the unnecessary delays, especially when it comes to land matters, and even at the Supreme Court, with regards to chieftaincy issues that goes to the Supreme Court? Sometimes 30 years, 40 years, and the cases are still pending. What accounts for all these delays, and what do you think we should do to expedite action on these cases? Because it is said that justice delayed, justice denied.
Thank you, Mr. Chair. The delays in adjudicating is a concern for everybody. And even as the judiciary, I don't think I'm happy about it. But some of the reasons are out of our hands. The courts are inundated with cases. We have not more than 460 magistrates and judges for over 30 million people. In the United Kingdom, they have 30,000 magistrates and judges for a country with the same space as Ghana. And therefore, we have challenges. And we cannot add more judges because we do not have courts. It may interest you to know that an area that is as densely populated as Dansoman or Nungwa doesn't have any court. There are so many between Obuasi and Kumasi. There are no courts. On the Ekwapim Ridge, from Ayi Mains Bekwa, okay, so maybe that is the exception. From Ayi Mensa to Aprade, there are no courts. It's just recently that one was built in, I think, Aburi and another place. So we have challenges. There's the need for investment in the judiciary. But, Mr. Chairman, I'm done. I'm saying that there is need for more investment in the judiciary. Thank you.
Yes, yesterday I was at a place where the Chief Justice lamented the challenge, but he also announced that about 120 new courts being built, and the challenge is how to man them now. He needs about 4,000 man staff. So that is where Parliament's direction is sought to assess to make sure that they have. So Body and his village, Eric's village, will get a court each. Yes, please continue. Very soon, so don't worry.
Thank you very much, Mr. Chairman. Mr. Chairman, the nominee was the for the 3-member committee of inquiry into the killings of Ejura in the Ashanti region. No, it's not this one. Okay, sorry. It's Kumsinada somewhere. Sorry. Mr. Chairman, I want to go back to the first observation by the minority leader with respect to the capping of the Supreme Court. Mr. Chairman, the U.S., with their population over 300 million people, have 9 Supreme Court justices. Canada also has 9. Now with 30 million, when you are approved, we will have, I think, 19 or 18 Supreme Court justices, if approved. Looking at the economic situation that the country finds itself today, do you think we should continue to increase appointment of justices to the Supreme Court, or we should have a limit or a ceiling to the Supreme Court, looking at the economic situation that we find ourselves? Thank you, Mr. Chairman.
Yes.
Mr. Chairman, I believe I have already stated that we do not have 18 judges. Around 15, and that judges are appointed or nominated to replace retiring judges. Secondly, I have also referred to the workload as a result of the multiplicity of cases before the Supreme Court, and the fact that they are as of right, and therefore the Supreme Court is inundated with cases. As to the expense, I believe that the role of the judiciary is to promote law and order, and therefore we should do a balancing act between the expense and the need for law and order. And I would say that if we think that peace is expensive, we should try war. Thank you.
Yes, Eric.
Thank you very much, Mr. Chairman, for the opportunity to ask some few questions after my honorable colleague Samson Ahi has just ended. Mr. Chairman, my first question has to do with the trust of Ghanaians in the judicial system. And I would like to quote from Ivan Kaufman, a judge in the United States of America, who once said, "The Supreme Court's only armor is the clock of public trust. Its sole ammunition is the collective hopes of our society." The Afrobarometer Dispatch, number 347, dated 28th February 2022, indicated that Ghanaians believe in the legitimacy of their justice system, but many citizens think the courts are corrupt, untrustworthy, and unfair. Specifically, the report indicates that 16% of the Ghanaian population believe, 16% of the Ghanaian population trust the judicial system, and a whopping 84% of the Ghanaian population do not trust the judicial system. This can undermine judicial integrity in our system. What do you think can be done to restore trustworthiness of our courts and to reverse the dwindling image of the courts in Ghana?
Thank you, Mr. Chair. Let me start by saying that I agree totally with the quotation that you started with. However, and it is a fact that there is some amount of corruption, but I do not think that the Afrobarometer, the statistics that they have, is correct. Because when they talk about the judiciary, they bunch all of us together. They bunch judges together with judicial staff, with investigators, with prosecutors, and bunch it all together as the judiciary. So maybe we will need a more scientific way of determining this. But having said that, it is also a fact that even the slightest loss of trust and confidence is not good for the judiciary. And it behoves on all of us. From the Afrobarometer, almost every aspect of our society, there is corruption. So as a society, I think we should also look at this. And
Chairman, with your indulgence, just a little follow-up. Are you suggesting that the Afrobarometer is not scientific?
From where I am sitting, that is the impression I get.
That there are research and survey not scientific?
Well, I would not, maybe the use of scientific is stretching it, but I was referring specifically to the judiciary.
What's your definition of the judiciary? The bunch of you, who are you? Who do you constitute?
The judiciary is made up of judges, and then we have the judicial service. There is a distinction.
Who is responsible for the administration of justice?
The Chief Justice plays a dual role. He is head of the judiciary as well as head of the judicial service. So
does the judicial service help the judiciary or not, the bench?
Oh, we cannot survive without the judicial service.
Is there a relationship?
There is.
And in that nexus of a relationship, can there be compromises that borders at the integrity of those who serve in those offices? Thank you, Chair.
Does what are alleged to be done by or misconduct of judicial service staff affect the judiciary proper?
Yes, there is a link. As I stated earlier, we cannot do our work without the judicial service. Definitely. But the point I was trying to make is that when it is stated that the judiciary is corrupt, or when allegations are made against the judiciary, a lot of people are not able to distinguish between the judges, the staff, and other stakeholders. And that was the point that I was trying to make.
Chairman, if I still have your indulgence. No, I'm done, but just follow up. If you have a judicial officer, staff, pay money, cash, or a good or ship to a judge who accepts it and gives a compromising judgment, what do you expect Afrobarometer to do in that instance? Thank you.
Mr. Chair, I believe the example you just gave goes directly to or impugns the integrity of the judge. But what I am saying is that when the data is being put together, they don't look at only the judges. They look at other stakeholders and bunch all of us together. That is all that I was saying.
My ladyship, I was helping you. We all do good and evil in the name of God. You have a judicial officer who uses a judge's name, go to engage in a compromising conduct that probably is not related to the judge. And fairness to the judge, he may not even be aware. But as far as a client far away is concerned, I saw an officer to see a judge on my behalf. If Afrobarometer captures that, will you still describe that as unscientific?
Mr. Chair, I believe I have withdrawn the use of the word unscientific. I used it loosely. What I meant to say was that the data, as I know, is not accurate. Thank you.
Yes, Eric, we'll continue.
Mr. Chairman, to follow up on the first question, the 2021 Human Rights Report of the United States of America on Ghana indicated that judicial officials reportedly accepted bribes to expedite or postpone cases, to lose records, or issue favorable rulings for the payer of the bribe. First, the issue of loose records or missing case dockets have been witnessed in court proceedings, which delays delivery of justice. What mechanisms do you propose to remedy this situation if given the opportunity?
Thank you, Mr. Chair. I think what the honourable member just said actually confirms the point that I have been making, that judicial officers comprise judges and other officers, but mechanisms that can be put in place in the judiciary. We have complaints units. Maybe more can be done. No system is perfect. Every system can be improved, and therefore maybe we will have to strengthen the systems in place now, because as I indicated, the least mistrust is not good for the image of the judiciary. Thank you.
Mr. Chairman, Professor Atuguba of the University of Ghana did a research on the Supreme Court of Ghana. His research findings on the Supreme Court of Ghana suggested that rulings on some 100 political cases for the past 25 years have gone in favor of political parties that appointed the judges who sat on the cases. What is your take on this important finding, which borders on the integrity of the Supreme Court and undermine the delivery of justice in our country?
Thank you, Mr. Chair. I do not have access to the data that went into this finding, and therefore I am not in the position to say whether it is accurate or not. Suffice it to say that from my experience, I do not think that judges' decisions or rulings necessarily go in favor of the appointing authority. There are coincidences do happen, but I cannot state for a fact that that is the case. Thank you.
Very well. Yes.
Thank you very much, Mr. Chair. Congratulations, my lady.
Thank you.
Alternative Dispute Resolution Act 2010, Act 798 is 12 years. Will you say that Ghana has taken ADR seriously?
Thank you, Mr. Chair. There is a lot of room for improvement. We are taking baby steps. There is a lot of room for improvement. And as I indicated, what we need is education and the awareness of all the good things and benefits of ADR. Unfortunately, even though the law makes provision for the establishment of an arbitration center, we still have not done it, which is not a good signal to the outside world that we are serious about ADR. Thank you.
Thank you. Well, congratulations on your book, Alternative Dispute Resolution. I'm excited that you co-authored it with one of the finest judges in Ghana, who happens to be my pupil's master, Sedeni Seji. Yes. There is a school of thought which says that once you are convicted of murder, you should die. Another school of thought also says that there can be new evidence which suggests that the person did not actually commit murder. So capital punishment should be abolished. What is your take on capital punishment?
Thank you, Mr. Chair. Speaking as a judicial officer, I am bound to follow the law as it stands upon determination of all the evidence that is placed before me. But speaking as a person and as a Christian, I do not believe in life for life.
And by extension, death for death.
Yes, and but as I said, the law is as it is, and we are bound to follow it. Thank you.
Did you preside on an assizes in your time at the High Court?
Mr. Chair, no. I was in the commercial court for the longest time. Thank you.
I hope you stay there only. Because I believe firmly in life for life. That's right.
My lady, a look at your CV. It's not numbered, so where we have educational background. The first one, Chartered Institute of Arbitrators, UK, the Queen's College, Oxford University. You did it from September 2016 to May 2019 for a diploma.
Thank you, Mr. Chair. Yes, the diploma in commercial international arbitration is in two parts. The first part is a residential course that we did at the Queen's College, Oxford. After that, and then at the end of that course, you write a paper. The second part is relaxed. There's no time frame within which. So it is, you study, self-study. They give you all the material. You study on your own. If you can, or if you want to, you can go back to the UK for tutorials, or you can do it in-house. And then when you are ready, you write the exam. It is at the end of that, you pass the exam, that you're awarded the diploma. So it's very flexible.
Well, Chairman, with your indulgence, a follow-up to your earlier answer. As a judge, what will you do if your personal faith or conviction is at variance with the law? I'm coming back to her earlier question. When your faith and conviction is at variance with the law and you are presiding as a judge, what should we expect you to do? Thank you, Chair.
It depends on the facts of the case, the circumstances of the case. If it is something that I feel so strongly about, that I feel that I cannot be impartial, I will recuse myself. Thank you.
So if a matter like the discuss of gay rights, transgender and co come before you as a judge, I heard you sound with emphasis, I'm Christian, good Christian. That's your faith and conviction. What would be the relationship with that with the law? Thank you, Chair.
Mr. Chair, Mr. Honorable Chair, I am not clear in my mind whether the question was a direct reference to a specific issue or a general question.
I just want your answer to conviction and faith versus the law.
I think, Mr. Honorable Chair, my answer will still be, it will depend on the circumstances of each case. I will deal with it on a case-by-case basis. Thank you.
I want you to be saying that you will be weighing your personal morality against the law in the performance of your duty.
Most cases that come before the court do not require you to base your decision on your personal morality. Most of the time, we are required to go apply the law. And that is why I keep saying that it will depend on. I have not come across any case that would require me to weigh my personal morality against what the law says. And therefore, I'm not in a position to state categorically what I would do. But suffice it to say, if I feel strongly about it, I will recuse. Thank you.
Are you done?
One line.
No, please proceed.
No, nothing. When approved, you'll be the 6th female Supreme Court judge. I wish you well.
Thank you very much.
Oh, yes. Yes. I'll give you.
Yeah, thank you very much, Mr. Chair. I would want to, first of all, congratulate the nominee for her elevation into this position, and would want to promotion to, thank you very much, Mr. Chair, to this position, and we want to pick her further views in respect of capital punishment. Now, Justice Dochi, in the case of Dexter Johnson versus the Republic, 2011-2 Supreme Court of Ghana Law Report, page 601, particularly at page 702, had said that the time has possibly come for Parliament of Ghana to seriously consider to have a policy shift in the mandatory death penalty regime imposed on people convicted of murder. Your Ladyship, again, way back in 2010, the Constitutional Review Commission that carried out stakeholders' engagement across the country came to the conclusion that the penalty must be replaced with life imprisonment. My lady, currently there are about 172 persons on death row. And some people have been on death row for over 30 years. And when they are on death row, because they are not lifers, they are in condemned cells. And so they don't have the benefit of a person as on a life sentence. This condition has been described by various stakeholders as a gross violation of the rights of these people. Because if you kill them, then kill them. If you cannot kill them, then they must be on life. Currently, this Parliament is considering some bills that aims at replacing the death penalty with life sentence. What, in your view, you say, in your personal view, or if you have the opportunity, would you support the advocacy for the removal of death penalty from our statute books? Thank you very much.
Thank you, Mr. Chair. I can understand where the honourable member is coming from regarding the fact that even though we still have death penalty in our statutes, we have not actually executed criminal or people who have been charged with those offences in a long time. In fact, I'm aware that Ghana is described as an abolitionist in practice. But I believe that it is for this Honourable House to then look at the existing law and make a determination, taking all these factors that we have talked about into consideration in coming to a decision as to whether it should stay in our statute books or be removed. The aspect that is in the criminal offences law, there is an aspect that is in the Constitution that might require some constitutional amendment. Thank you.
Mr. Chair, I would proceed with my question. Honourable Nominee, you are a member of the International Center for Law and Religious Studies and a member of the College Advisory Board for College of Humanities. And from your earlier answers, you have presided over a number of disciplinary, or you have been a member of a number of disciplinary bodies of the judiciary. This means that you have come face to face with matters of administrative justice and the requirement by Article 23 of the 1992 Constitution and Article 296 of the Constitution on the proper use of discretionary powers. Honourable Nominee, would you consider the directives by the General Legal Council this year on this year's entrance examinations, the directives to students in respect of remarking, retallying, and their rights, and the fact that they would not have any right to request for those, opportunities when they write the exams? Do you consider the said directive as a bit arbitrary and contrary to these laws, particularly when you are approved, you are going to be matching these directives against the Constitution of Ghana?
Thank you, Mr. Chair. Please, what was the second provision you referred to? 23 and...
Article 296, please, on discretionary. Article 296. Yes, Article 23 on administrative justice and Article 296 on the exercise of discretionary powers.
Thank you, Mr. Chair. Honourable Chair, I'm sorry, Honourable Chair. From a quick reading of the two provisions, the combined reading, my understanding is what comes out to me, firstly, is the use of discretion, and secondly, the fact that there are avenues for redress. So, sitting here, I cannot conclude that the undertaking is unconstitutional. It will be presumptuous of me to do so. Neither can I say that it is arbitrary. Arbitrary power is definitely frowned on by the Constitution. And therefore, since per these articles, there is the provision for anybody who is aggrieved to take the matter to the court, I believe that is what we should be concerned with, that there is the avenue. And the court will determine this based on the circumstances and the facts of each case. Thank you.
Honorable Chair, as a follow-up on that answer, whilst there is indeed an avenue for redress, many people over the years, both lawyers and people in civil society, have raised concerns of the fact that the General Legal Council, as established by Act 32, which is the Legal Professions Act, by law requires that the Chief Justice become the chairman of the General Legal Council. Now, being the chairman of the General Legal Council, the Chief Justice automatically assumes responsibility of whatever happens with the General Legal Council. At the same time, it's the same Chief Justice that is required to empanel judges, for example, and in the event that this matter is ending at the Supreme Court, by law, he is supposed to preside, unless in his absence a senior judge. So this creates very serious issues of demanding accountability of the General Council itself. What would be your view, particularly in respect of people calling for reforms of the General Legal Council to remove Superior Court judges from the General Legal Council to make it purely administrative?
Thank you, Honorable Chair. I think that we should adopt the attitude that the law was well intended. So just as we have the Chief Justice and Supreme Court judges on the Legal Council, we also have lawyers. We have the President of the Law of Bar Association, immediate past President, and the Attorney General on the Judicial Council. So it is a fused profession. We have lawyers who become judges. So I would hasten to change the law unless stakeholders are of the opinion that there is some abuse and which should be looked at. Then there should be extensive stakeholder consultation, but done dispassionately. Thank you.
Mrs. Chair, thank you very much for your answer. In your earlier answers, you had made copious reference to best practices from the UK, especially in terms of the number of judges and the number of cases that go before them. Would you say that at a time that there is at least some modicum of distrust of the appointing processes of justices, and sometimes even promotion processes of justices, we should begin to look at the UK example of establishing Judicial Appointment Commission, which is more independent and which makes a recommendation that cannot be changed. And once they make the recommendations, it is followed by the administration, whichever administration that may be.
Thank you, Honorable Chair. I have said before that the law is dynamic, so at every point in time society can look at it, and depending on the needs at the time. But as far as I'm concerned, the Constitution lays down the procedure for appointments, and I personally do not see anything wrong with it, because I see it as a balancing act between the executive, the legislature, and the judiciary. And at the end of the process, we appear before you, as I am doing today, to be vetted and hopefully confirmed. And I would say that if it is not broken, you don't fix it. Thank you.
As a follow-up, Mr. Chairman, I think that maybe contrary to the views of the nominee, there are many people who think it is broken, and particularly because it has to do with the judiciary. Any slightest distrust must be of a worry to all of us, because we believe that it is only the judiciary that can hold balance situations in the country and promote peace, as you have already said. My lady, if you look at the very old case of R versus Sussex Justices, Espati McCarthy, it is said that justice must not only be done, but must be seen to be done. What that means is that the general views of the populace really matter. And also, if you look at Article 125, it says that justice emanates from the people and is administered on behalf of the people. What that means is that every Ghanaian has some sense of what is fair and what is not fair. And to that extent, any research whatsoever that shows that there are some people who are uncomfortable about how the processes of appointment, promotions are concerned, I believe that it should be something that should be of worry to us, and we should be able to take a look at that.
Honorable Chair, I agree with you. As I have said over and over again, the least indication that there is mistrust is a worrying factor. And therefore, I would say that all stakeholders can have this conversation and decide what is in the best interest of the people that we serve. Thank you.
Congratulations, Honorable Nominee.
Thank you.
Yes, Honorable Zura.
Thank you, Mr. Chairman. Good afternoon, Honorable Nominee, and congratulations. Honorable Nominee, I'm looking at your CV, and I'm looking at awards and honors. And you got an award in athletics. And, do you still do any sports?
Thank you, Mr. Chair. Yes, with all due humility, yes, I was one of the best athletes for my school in my day. I was doing the 100 meters, 200 meters, 4x100 for Wesley Girls all the 7 years that I was in school. Unfortunately, old age has set in, so I am not able to do as much, but I try to walk. Thank you.
Thank you, Nominee. I will take it from there. You still walk, and I want to believe that you still have the experience from then. And you know, there's a school of thought that says that sports brings people together, including that it creates communities. It also says that it gives a certain sense towards social justice. And social justice mainly is what? A sense of inclusiveness, equal opportunities for everybody, a sense of justice. I've taken you back so that I can ask my question properly. My question now that we know who you are, within that context, what is your view on the role of the Supreme Court in our democracy and transitioning democracies? We're also looking at, as our democracy evolves, how does the Supreme Court support the development of our democracy and in the end improve the lives of the multitudes of poor people and the vulnerable? What would be your thoughts on this? Thank you.
Thank you, Honorable Chairman. That is a very interesting question. I would link the role of the Supreme Court in our society to the role of the judiciary as a whole, but with the exception that the Supreme Court is the apex court in our land and the last resort. And therefore, if a case travels to the Supreme Court, you don't have any further redress. So for that reason, the Supreme Court plays a very important role. And we know that the judiciary has a critical role to play in maintaining our democracy and law and order in our country. And therefore, the role of the Supreme Court in social cohesion cannot be underemphasized. I think that we should all appreciate the important role that the Supreme Court plays, especially access to justice, which is the right of every citizen of Ghana. Thank you.
Thank you, Mr. Chairman. My second question, Honorable Nominee, is in the fourth Republican dispensation, we've had 8 elections: 1992, 1996, 2000, 2004, 2008, 2012, 2016, and 2020. Out of the 8, we've had 3 of these election outcomes at the doorsteps of the Supreme Court, that they've attracted petitions from the contesting parties, whereas we had different parties as petitioners. There's a constant in all the 3 cases, and that is the Electoral Commission. Now, out of 8 elections, if you have 3 of them going to the Supreme Court for adjudication, does that tell a certain story? Does that give an indication that we probably need to begin to look at the constant in these disputes, which is the Electoral Commission? What will be your view if you get appointed to the Supreme Court? What will the Supreme Court do in order that we can sort of cut down on the number of times political parties or get aggrieved and end up at the Supreme Court? By all intents and purposes, elections should end at the Electoral Commission. Thank you.
Thank you, Honorable Chair. I would agree with you that the preferable situation would be that all elections should end at the with the electorate, yes. But every Ghanaian has a constitutional right to go to court, and therefore one cannot stop anybody from going to court. Fortunately, as our electoral rules are statutory and based on common law, so if we feel that there is the need to put any laws in place that would guide the role of the Electoral Commissioner, it is up to this honorable House to do so. Thank you.
Yes,
thank you. My last question.
Oh, you have had 3 already, more than
2.
Oh, very well.
2,
You
Mr.
take
Chairman.
one more.
Thank you, Chairman. My last question. The general public has been very concerned about some of the decisions lately, rulings from the Supreme Court, and some of them include that undermining the value of a birth certificate as a source document for one's nationality. there's been a constitutional injunction not to have persons above 65 years in regular appointment in the public services. There's also one that undermines the ability of Parliament to conduct its own affairs without micromanagement by the courts as an incident of separation of powers. There are so many others in the public domain, and that has raised questions about the neutrality of the Supreme Court. What are your views about some of these judgments?
Thank you, Honorable Chair. It is very unfortunate when decisions are made and people form opinions, probably knowing the circumstances and the details of the case. But, Honorable Member, these are live issues, and you have indicated that these are issues that have been ruled upon by the Supreme Court. And therefore, as a judicial officer, I am bound by those rulings. Thank you.
Okay, are you still interested in asking a question? If you show your hand, I'll give you the opportunity. Well, there's been three ladies. Let me give it to the gentleman before I come to you.
Thank you very much, Mr. Chairman. Congratulations, Honorable Nominee. May I just take you back to some preliminary issues with the CV first, Mr. Chair? It's not numbered, so that talks about employment history as the heading. I see Roman numeral 5 to X. No, Roman numeral 5 to VIII. Maybe for consistency, could you also indicate the months associated with the years? For example, V, Ashanti Gold Company Limited, Manager Legal Services, 1997 to 2000. I see that in the others you indicate the month starting and the month completing. Can you consider adjusting that for consistency? Now, to my substantive questions, Mr. Chair. I'd just like to get your views on congestion in our prisons. There is an overwhelming perception that apart from the squeeze of space in prisons that we have, I mean, governments not putting up new prisons here and there, but the most critical factor that is contributing to this is the delay in justice delivery. Now, if you get confirmed to the Apex Court, what ideas do you have for some form of reform to ensure that these congestions can be done with, but be done away with? Thank you, Mr. Chair.
Thank you, Honorable Chair. I believe I have already spoken on some of the causes of delay in the judiciary to do with infrastructure and logistics. But I think another way of addressing the issue of congestion in our prisons is to look at the sentencing mechanism. We could have more non-custodial sentencing rather than sentencing offenders to go to prison. And then secondly, there are some concepts that are equivalent to ADR in the criminal justice system that we could apply. One of them, which we have already done, is plea bargaining. And then we have what we call victim offender conferences, which we don't have here, which we could introduce to alleviate the problem of congestion. Thank you.
Thank you, Honorable Chair. My second question has to do with, again, there has been a lot of talk about perceived corruption in the judiciary. I just like to get your views also on political corruption. Recently, there's been an expression of political judgments. I don't know whether you've heard that. Now, looking at your CV, it looks very impressive. And you are just going to the Supreme Court. Hopefully in 2.5 years, you'll be retiring. You want to look back and be happy. What do you think you can bring on board to tackle this unfortunate perception of political judgments coming from our courts? Thank you.
Thank you, Honorable Chair. I would be grateful if the Honorable Member could explain to me exactly what he means by political judgments.
Mr. Chair, I'm sure my lady has heard reports, etc., about unanimous FC, etc., etc., where in particularly judgments from the Supreme Court relating to presidential election petitions. The most recent one had this perception and description by a section of Ghanaians that every ruling that was coming up was unanimous. And it was strange, perceived by many, that judges in their own rights could not prefer counter views or opinions, but gave that unanimity. And so that became a concern, whether rightly or wrongly. My thinking is, do you have some comment on that unfortunate perception and whether something could be done about it? Thank you.
Thank you, Honorable Chair. I'm sorry, I don't do social media, so I don't know a lot of the things that you're talking about. But on the issue of the unanimity, I think it is, with all due respect, a lack of understanding of how the courts work. We have developed the law to a large extent, and so with precedents there and stare decisis, a lot of things are settled, and therefore there may not be the need for every single judge to give an opinion on a settled aspect of the law. So from the outside, it may look like everybody is towing one line, but maybe because that area of the law is settled, unless there is the area of the law is recondite, or the evidence, everybody has a different view as to how to evaluate. That is when you have different judges writing differently. In any case, before any judgment is delivered, the court will hold a conference, and everybody is free to ventilate his or her views, and nobody stops anybody from dissenting. So that is the position of the law. Thank you.
Mr. Chairman, my final question. My lady, I see that you are still in the appeals court. You've been here for like 11 or so years. Am I right? Yes. So 10 years. That appears to me like a very long wait. Do you feel that this is coming way too late? And do you have a recommendation on how long we probably should wait at such a level? Thank you.
Thank you, Honorable Chair. I am a judge to do the work as assigned to me. I do not make a determination as to when to be promoted or not. I just do my work as required. I do not think it is ever too late. I believe that it does not depend on how long a person stays in one position, but the quality of your output and the impact that you make. Thank you.
Chairman, Honorable Judicial, if I can have a bite of a follow-up. Your leadership, we appreciate that you are coming from the Court of Appeal to the very respected Supreme Court of Ghana to adjudicate justice and to be fair to all manner of persons as your judicial calling. What our colleague, the Honorable Dr. Jesau, is trying to elucidate from you is an observation within the bench, that when it comes to appointment and promotion, there is no balance. No balance in the sense that, for instance, you've been at the appeal court. Look at the number of years you have served. Probably, if you were not lucky you were called this time, you would have exited without realizing your lifelong dream of Supreme Court. Then somebody from the High Court who has not walked the path to an appeal court is run over you. That is his concern. Is run over you to the Supreme Court. That, within the meaning of Article 296, cannot be fair. Cannot be fair. So whether it's the president as executive president or parliament as an institution or the chief justice, the fairness implies that in promotion and appointment to the bench, and we are not directing it at you. The failure is a political elite again. No, it's an observation to Dr. Jesau. There are many high court judges who are long in the queue. They are not being recognized to go to Court of Appeal. That cannot be right. So he's just asking for your opinion. It's not directed at you. You are not the appointing authority. But we are concerned that as a country, let's be fair to all manner of persons. Thank you, Chair.
Honorable, I think this was not a question. It says it's a comment. If you want to comment on the comment, I'll allow you. If not, you're free to decline. Very well. Yes, before, yes.
Thank you, Mr. Chairman.
Live pure. To right, wrong, follow the king.
Yes. Allow us to say, I could. Your Ladyship, I see your CV. You were elected as the first president of the Association of Female Women Judges. What impacts did you make at the time, and since then, with your experience from that time, what impact do you think you'll be able to make on the female judiciary, human capital, and the system? Thank you.
Thank you, Honorable Chair. The International Association of Women Judges is an association that seeks to promote human rights, especially those of women and children. And there is an interaction between judges from different jurisdictions so that we can share best practices. And they also organize training programs towards their goals. As the first president of the Ghana chapter, the executive, organized conferences for both male and female justice to bring them up to speed on gender and issues and rights and children issues. We also organized a conference for Queen Mothers to again bring them up to speed on gender and children matters, because we saw that there were some cultural influences. We also produced a film, a short film called A Call to Justice, in which we were educating the public on women's rights and children's rights. The script was actually written by a judge who was a member of the executive, and we showed it on Ghana television. And these programs are continuing under the leadership of those who took over from me. So we are doing a lot. We are doing our bit. Thank you.
All right. I think you could advise that perhaps they could increase the tempo a bit, because I believe education is never the lifelong process.
Well taken.
With your experience, your knowledge and experience in ADR, how do you see this impacting on traditional justice systems? Because in our rural communities, our chiefs, a lot of cases are sent to the chiefs. How do you see them being properly documented, whether some case management, being able to share the outcomes across even the traditional systems or the more formal systems of case management, let me put it that way. What do you think could be done to have that integration from the traditional systems to the more formal systems? Thank you.
Thank you, Honorable Chair. I believe that we have taken a huge step in that direction with the inclusion of customary arbitration under the ADR Act. And therefore, under the ADR Act, it provides the how customary arbitration should be conducted, which is a little different from the way traditionally it used to be done. And therefore, I believe that the chiefs, and I think it has started, need to be educated on this. Thank you.
All right. Again, I think that if this is how the ADR environment is structured, I believe you could also put it to the Chief Justice to be able to bring that down to the level of the traditional justice system. I've been involved in some training for chiefs, but it's more got to do with land matters and it's more land management. But I think the general skill of being a fair judge in cases with something that would benefit them across the country, because we've talked about the deficit of magistrates and judges in that formal system. So the much more informal system could benefit from that.
Totally agree. Thank you.
My last question is, we're not going to drill you like, we didn't drill you like Ketanji Brown Jackson, but you know, this is not the equivalent of that. But you have 2.5 years approximately to retire. What would you want to be remembered for in this 2.5 years? That would be a signal to women in leadership, both general leadership and in judicial and legal leadership. Thank you.
Yes, as I indicated, thank you, Honorable Chair. I'm sorry. As I indicated, it does not depend on how long you are in a position, but the impact that you're able to make. And I would want to be remembered for groundbreaking decisions on the Supreme Court bench. I would want to be remembered for my integrity. I would want to be remembered for my fairness.
And I think if I'm able to achieve these within the 2.5 years, I will be very happy. Thank you. By God's grace.
Chairman, does that imply that she doesn't want to be remembered for being courageous and fearless?
I just gave a few examples. Yes, I want to be remembered for being fearless and courageous. Thank you.
Yes. Thank you very much, Mr. Chairman. Congratulations, Your Ladyship, for your nomination. Mr. Chairman, I just have maybe just 2 questions and a follow-up, but I cannot ignore curiosity that I see on page 2 of the nominee's CV. Born in Cape Coast, started school, it seems, at age 10 in Accra, and later went back to Cape Coast. So I'm just wondering what happened. Page 2. Page 2 shows that she started school at age 10.
Thank you,
Cape Coast.
Honorable.
You can ignore that.
I know exactly what you're talking about.
Okay.
I indicated in my CV that I was born in Cape Coast, but my family moved to Accra shortly after that.
Okay.
And I indicated that when we came to Accra, I attended Christ the King School. And that is where I sat my common examination. I did not think it was necessary to list all the schools before I sat for common entrance. That is what happened. Thank you.
Okay. Well, thank you for that additional information. Honorable nominee, I first of all will want to find out if you have identified any threat to our criminal justice system over the years that you have practiced on the bench, either based on cases that you have handled or just your observation generally. Have you identified any threat? Apart from, yes, the obviously known slow pace of investigation, discontinuing for lack of prosecution and all that, have you handled any case that you think brings about threats to the development of our criminal justice system?
Thank you, Honorable Chair. You're talking about, if I understand the Honorable Member, you're talking about threats to the judicial system and not to my personal self.
Yes, the judicial system.
To the judicial system. I believe you have basically named all of them, and we have others in these proceedings referred to them. The delays, the perception of corruption. I cannot think of any more. Thank you.
Well, so that will lead me to my follow-up. Mr. Chairman, I'm sure you recall a case involving Gregory Afoko to the Court of Appeal. It's about a gentleman who was arrested for the murder of Adam Mahama in the Upper East Region. Investigations and committal proceedings were all done. He was arraigned to stand trial. The trial completed. It was left with the filing of addresses by lawyers of both sides. Then the AG filed a nolle prosequi. He was subsequently rearranged for fresh committal proceedings. Honorable nominee, you have the case of Ashawang, which I won't go into, but the executive administrative use of the nolle prosequi has come under some scrutiny, and how that may be a threat to the criminal justice system, especially when you speak of fair trial and the right to a trial within a reasonable time. What is your view on that, if you like, unrestrained use of nolle prosequi by the state?
Thank you, Honorable Chair. I believe that the laws give the Attorney General that power, and it is assumed that it will be used in the interest properly and in the interest of the people. But if we feel that there are any abuses of that, the use of that discretion, I don't think that we are stopped from acting. Thank you.
Who should act in this case, in your view?
The person who feels, any person who feels that there is an abuse of the power.
Okay, I'm sure the point is made, but let me just move on to the next question that I have. Going through your CV, I noticed that you describe yourself as one of the pioneer judges of the commercial court, and you were president of the court from 2010 to 2012. So let me ask you a question on the economy. The country, we all know, is facing dire economic challenges right now. The cedi is almost junk. Fuel prices have just been upped. We all have felt these things, so I will not bore you with more examples. But in the midst of this, businesses which are struggling to survive are being closed down by the tax and other regulatory authorities. What do you think the judicial attitude to these should be? She's not a commercial court judge, but she prides herself as a pioneer judge on the commercial courts in her CV. That's why I premised my question on that. So what should be the judicial attitude to this?
Thank you, Honorable Chair. Yes, indeed, I do pride myself as one of the pioneer judges of the commercial court. And as a pioneer judge of the commercial court, I applied the rules that were there for me to apply. I am not, as a judge, allowed to look at extraneous factors in coming to any determination, and therefore, as a officer, I do not think, with all due respect, that I can comment on the economy. Thank you.
Chairman, just a follow-up. The invitation by the Honorable Soyene is not necessarily on the economy. We know it's not Ken Oforiatta who is before us, rightly. But Chairman, the Honorable Soyene is raising a vexed legal issue of whether the regulatory bodies, such as the Ghana Revenue Authority, is not acting in a manner which is extrajudicial. That even by their law, if there are offenses to your administrative processes and practices, must they come before you for authority to act, or they can walk as regulators to be closing down shops. That is what he's invoking, not the question on the economy. Thank you, Chair.
Thank you, Mr. Honorable Chair. Yes. Regarding the issue that the Honorable Member has just raised, I believe that as an institution, there are rules and regulations that cover their actions. And sitting here, I'm not in the position to know, because I'm not familiar with their rules, as whether they exceeded their powers or authority. Thank you.
Yes, sure, done. All right. My lady, congratulations on your nomination to the Supreme Court. I took time to read a number of your rulings in the Court of Appeal. Very impressive rulings. But sitting here and listening to you, I'm tempted to ask you why Supreme Court judges in Ghana and aspirants to the Supreme Court bench in Ghana pretend that there is nothing political about the work that they are going to do at the Supreme Court. Why do you pretend? You and those who are already there.
Thank you, Honorable Chair. Honorable Member, with all due respect, I acknowledge the issues that the Supreme Court deals with, which you may interpret as political, probably are constitutional matters, and which are part of the jurisdiction of the court. I would not interpret them as political. Thank you.
Let's do a little bit comparative law, comparative constitutional law. You take South Africa. They have the Supreme Court of Appeal, which is the apex appeal court in South Africa. Then they have the Constitutional Court of South Africa. And the Constitutional Court deals with the constitutional issues. How are you going to tell me that in determining the relationship between the legislature, between the central government and the local governments, between the different centers of power, and determining who has acted ultra vires or not, how are you going to tell me that this exercise is not political?
Thank you, Honorable Chair. And I would add that in Uganda, the Constitutional Court is the Court of Appeal and not Supreme Court. But I would say that the framers of our Constitution felt it wise to make the Supreme Court of Ghana the Constitutional Court. And I would repeat that in my view, constitutional issues are not necessarily political issues. Thank you.
Sitting there, my lady, you just give some indications about your own political preferences on some matters. Yes, maybe you didn't notice, but you asked questions about life and death, and you appear to have some choice there. You also appear to have some, yeah, exactly. People are confusing partisanship with politics. You may have also some political views on gender relations between men and women. Okay? Now, how are you going to convince me that when you sit there as a Supreme Court judge and these matters come before you, your own politics in relation to gender or your own politics in relation to religion will not inform the work that you do?
Thank you, Honorable Chair. Honorable Member, I would not describe my views on gender issues or
life as politics. Maybe that is where I'm coming from, that the Supreme Court does not do politics. These are my views with regards
So you have views there?
Yes, I do.
Okay.
I do have...
Now, let me just stop you there. As we speak, Americans are preparing for midterm elections. And the vexed issue in that election is about abortion. Pro-life, against life, and that kind of thing. And this is going to form an entire national election campaign. So what you think are just your views are clearly what we consider as political matters. So my question is, why do our Supreme Court judges pretend that there's nothing political about the work that they will be doing, and then, pretend that what Dr. Atuba wrote about the fact that their political alignments or preferences tend to inform their decisions? That's actually what my question is, but I started from somewhere.
Thank you, Mr. Honorable Chair. I think it is a play on words, with all due respect. I do not consider judges as politicians, and that is where I'm coming from. So our views may not necessarily be political. Thank you.
This was just one question. Okay, last one. One more. Okay. The second one has to do with your views on public perception about judicial corruption. And I listened to you carefully. You tried to make a distinction between the judicial service and the judiciary, which is the judges and the supporting staff, essentially. But you know that every judge is supposed to take full charge of their court. The judge is supposed to take full charge of the court. How the service staff behave, how the prosecutors behave, how the lawyers behave, are all matters that you as a judge, when you are in court, you take responsibility for. So how are you going to convince me that if the public perceives that the judiciary is corrupt because judges are not taking charge of their court and letting the public see that justice has been manifestly done, how are you going to convince that the public is wrong?
Thank you, Honorable Chair. I will try my best to convince you that as judges, we are in charge of our courts, and cases that come before us, we are supposed to be in the driving seat when it comes to cases. But we are not in control of all the judicial staff. In fact, most of them do not work under us. And therefore, I think it is proper to draw a distinction between judges and judicial staff to a large extent. Thank you.
Thank you very much. I think I'm limited in the number of questions I can ask, but I wish you the best. Yes, you are late, so I'll give you 2.
Thank you very much, Mr. Chairman. My lady, congratulations on your nomination. I come on the land tenure system in Ghana. My lady, you'll agree with me that most lands in this country are held under customary tenure, which is vested in the chiefs, head priests, and all that because of where they come from. Now, potential investors and those living in the diaspora, including even those in this country, over the last decade or two, have had serious challenges with respect to the land tenure system. There are boundary issues, litigations between chiefs and others. This in many cases result in delays in determining who is a legitimate owner of a parcel of land. A classical case, an example, is between two investors who have litigated over land for the past 23 years. Just in Accra here. 23 years. Now, my lady, my question is, what will you do when you are giving the nod to ensure that cases or land cases that ends up in courts of competent jurisdiction are dealt with in a manner that will give confidence to persons who want to have confidence in the land tenure system, taking cognizance of government's agenda to introduce or rather work on introducing the digital system in the land tenure system. Is it the case that we don't have more lawyers? Is it the case that we don't have evidences to work on these cases?
Thank you, Honorable Chair. I think the issue of land cases and the length of time it takes for them to be adjudicated on is a concern to everybody, especially the judiciary, and for that reason specialized courts were set up, land courts, to handle just land cases. The courts are inundated with cases that the delays are still appearing. Basically, the issue is with land ownership. In other jurisdictions where land is owned by the state, you don't have these issues. So this is the situation we have, and the courts are doing their best to deal with these land cases. As I said, we have specialized land cases that are trying to adjudicate on these cases as best as they can. Thank you.
Mr. Chairman, is that true? Mr. Chairman, I'm still on delay in cases in courts. We've had cause to believe that prosecutors are becoming more or less not too motivated by sending cases to courts, because after going through lengthy processes of conducting investigations, cases will go to court, and in some cases bail are granted, and then it drags on and on and on and on. They effect arrest from one place to the other, and the person continues to get bail. My lady, what is it that we can do to fast-track cases in courts so that prosecutors and criminal investigation department will be encouraged, for that matter, to ensure that people are given their chance in due process?
I know, but the Honorable Henry, in his question, is questioning bail. He used the word bail. Chairman, bail, even the law says that the denial of bail by a judge itself constitutes the abuse of discretion. So if you can withdraw the word bail, as if you have a problem with the granting bail when it is provided for by the law, just that, Chairman.
Could answer. Let her answer.
Mr. Chairman, I take note, I rephrase. So I will concentrate on delay of cases in courts so that at the end of the day, justice is delivered.
Thank you, Honorable Chair. I believe that just as the prosecutors are complaining about delays, we are also complaining about prosecutors. So we think we all have to up our game and move the cases as fast as we can. Thank you.
Very well. She has to go elsewhere, so. Yes,
Chairman, thank you. Let me commend the nominee. Congratulations for being nominated. Chairman, let me start on this note. I've heard the nominee speak to the fact that we have a challenge as a nation in terms of availability of judges to dispense of justice in this country. And the impression comes to me that probably legal education in our country has to be looked at again. It may not come directly under your remit, but just to tease your mind, in the face of the happenings and the narrative, particularly about legal education, generally in our country now, if you are asked to make recommendations to, for want of a better expression, sanitize or better the situation, what will be your recommendation as an attempt to generally improve legal education in Ghana now? Mr. Chairman, this is my first question.
Yes. Thank you, Honorable Chair. That should be the concern of every citizen, since they are our future leaders. The population is growing, so definitely the number of people who want to read law is also growing. I would just talk about the accreditation for law faculties. Maybe that is an area that we should look at, so that we maintain the same standard in every institution. I think that is what comes to mind immediately. Thank you.
Chairman, just on when you say accreditation, what about it? Do you have a problem with the improvement of law schools, the ease with which accreditation is granted, or you think that accreditation is not being done consistent with acceptable standards? Let's get your message clear. Thank you, Chair.
Thank you, Chair. Everything that you have said.
Mr. Chairman, Mr. Chairman, the nominee has demonstrated demonstrable competence when it comes to ADR. Very admirable feature, and I want to commend her highly on that note. I see you've taught it, you've also studied it, and you've written it, and you've lived it. Very impressive. But I pose a certain dissenting view. I think that ADR has become, correct me if I'm wrong, it's become more of talk. What would be your legacy when we are speaking in the context of ADR? What would you want to be remembered of?
Thank you, Honorable Chair. I think the biggest contribution that I have made to ADR is co-authoring a book on ADR, which is the first textbook for students for reading law. Thank you.
Honorable Nominee, are you in a position to share with the committee what your judicial philosophy is?
aside ADR? Because I've heard you speak quite eloquently on ADR. I'm curious to appreciate your philosophy, your judicial philosophy. What are you bringing to the table differently?
Thank you, Honorable Chair. I know of a number of judicial philosophies in jurisprudence. Talk of formalism and all those. But I believe that justice, as our Constitution says, emanates and should be administered for the people. And therefore, I would prefer a philosophy of fidelity to the jurisdiction, to the Constitution, which contains all the directive principles of all the directive principles, and therefore in doing justice we should let the Constitution guide us. Thank you.
Honorable, do you have judicial role models? And if you do, are you comfortable speaking or mentioning these individuals, probably assigning reasons why they are your models?
Thank you, Honorable Chair. I think for me, every female judge who has risen to the heights in the judicial service is a role model, particularly the female Chief Justices that we have had. Thank you.
I think there have been a number of questions related to public perception, rightly or wrongly, against our judges. I differ. It's reoccurring and it's becoming almost real. Do you see judges as having a role to play in dealing with this perception? And if you do, what supportive efforts have you thought of when giving the nod to deal with this unfortunate perception against our judges?
Thank you, Honorable Chair. Definitely, everybody has a role to play. Even as a society, we all have a role to play in changing this narrative, but specifically with the judiciary. I have indicated that we have systems in place which, of course, like any other system, can be improved regarding complaints and petitions and whatnot. As individual judges, we also have a role to play in changing this narrative. And I believe that as judges, if we hold ourselves beyond reproach, that would be our contribution. Thank you.
Chairman, if I can indulge you for a follow-up. In your earlier answer to his question, the Honorable Anodombre, you use the words, the philosophy I will prefer, fidelity to the Constitution, and probably the laws of Ghana. Is it the philosophy you will work with, or you own your own philosophy, or we should take you by your words that is a philosophy somewhere you prefer working with? Thank you, Chair. You said the philosophy I will prefer.
Thank you.
Yeah. So bring that English here.
Thank you.
Thank you, Chair.
Thank you, Honorable Chairman. In relation to the use of the word I would prefer, I was comparing it to the established judicial philosophies of jurisprudence, but my philosophy is what I talked about.
This committee wants to record your philosophy, so share it with us, not what you would prefer.
So my philosophy is fidelity to the Constitution. Thank you.
Let me just conclude on this note. I'm reliably informed that somewhere in April, Chief Justice had given some directive that the age-old practice of cases of senior lawyers should be called in court and supposed to serve as lessons to junior lawyers. I don't know if that was the case, but that's what I'm told. Speaker, maybe you should allow me to ask the question. For the nominee, I may be exhausted. So, trying to tease your opinion. Yes, Speaker, I concede is an age-old practice. I am trying to tease the nominee's opinion because there are other views to that. What is your view? You think it should be protected or it should be amended? We should allow it to stay?
Well, for a start, this was supposed to be an internal memo, so I do not. Thank you, Mr. Honorable Chair. I'm sorry. As I started by saying, this is an internal memo as a practice directive. And I personally do not see anything wrong with it. Thank you.
Honorable, my Lord, that practice, is there anything wrong with it? Learning under the feet of your seniors while waiting to be heard?
Honorable Chair, that is exactly what I said. I said I did not see anything wrong with it. Thank you.
My last question, Honorable Nominee, if you become aware of unethical conduct on the part of a trial advocate, how will you handle it sincerely?
Honorable Chair, if I understand the question, are you asking, Honorable Member, what I would do if a lawyer misbehaved? I'm not sure I understand the question.
I'm curious to know the event of an unethical conduct being exhibited, be it a lawyer or anybody involved in a trial case, and it comes to you or comes to your notification, what will be your action?
Thank you, Honorable Chair. There are various options open. There could be a report to the General Legal Counsel. It depends on what the act is. If it's a contemptuous act, there are available remedies. Thank you.
Chair, I'm grateful, and I want to wish the nominee all the best.
Thank you.
Yes, when I teach you. Thank you, Mr. Chair. Madam, let me just start with your CV. Your CV shows that you joined the bench in September 2003. Am I right?
Yes, please. Yes, Honorable.
And Mr. Chairman, since then, I noticed that on your CV, you acquired diploma in international commercial arbitration, and this was between 2016 and 2019. You equally acquired executive masters in business administration between 2009 and 2010, and then between 2010 and 11, you acquired an international law. You attended an international law institute, African Center for Legal Excellence in Kigali. Am I right?
Yes, Honorable.
How did you manage to do this as a member of the bench? Because it's there. I've seen, apart from this, you have so many short courses that you take. Some are weeks, even though I see some of them are not during legal vacation. But how did you get to do this?
Thank you, Honorable Chair. For the programs that I attended while on the bench, either it was sponsored by the bench, or if I was doing it privately, I sought permission from the Chief Justice. And for most of these programs, as you indicated, most of them were short programs. With the Chartered Institute of Arbitration, as I indicated, it was a very flexible program, and therefore I did not have to attend classes throughout the period. The same applies with the EMBA. It was a 8-day class meetings every 2.5 months. And therefore it was not a program that took all my time for that period. Thank you.
Mr. Chair, I'm asking this because it has become a lot of common to see members of the bench taking public time for this kind of programs, and some even do other works that gives them profit. If you look at the Constitution and you look at, in the case of members of Parliament and ministers of state, if I, Muntaka, wants to carry out anything that would earn me money, I needed to come through a committee. I just don't write to Mr. Speaker and then he grants it. But in the case of the judiciary, you just keep hearing, oh, I wrote to the Chief Justice and he granted it. Don't you think that the time has come for us to regularize this in either rules or in a setup that is known to everybody? Your mic is on, madam, sorry.
Thank you, Honorable Chair. We have a code of conduct that is written. And if you permit me to refer, it says that a judicial officer or any person specially learned in the law or that is in a unique position to contribute to the improvement of the law, the legal system and the administration of justice. To that extent that time permits, a judge is encouraged to do so. So it doesn't go against our code of conduct.
So my understanding is that when it says time permits, yes, maybe during your legal vacation, because that time you are on vacation and the time will not conflict with the time that you have to sit on the bench. But let me just ask, the diploma in international commercial arbitration, which you took, I think, between 2016 and 17, did you seek permission to do that?
As I indicated, it was a flexible program. So apart from the part 1, which was residential, which I attended during my legal vacation, the rest of the program, I did it from the house. Thank you.
What of the Executive Masters in Business Administration,
yes,
which took place between 2009 and 2010?
I got written permission to do that.
And lastly, the International Law Institute, the one that was in Kigali.
Again, I sought permission, and that one, as similarly, did not require me to be there for the whole period. Thank you.
Mr. I want to find out from the nominee. She's been on the bench, like I said earlier, from September 2003 to date. Have you declared your assets?
Yes, thank you. Yes, I have regularly declared my assets. Thank you.
Where regularly here means every 4 years?
Approximately, I think. I know I have done it at least 3 or 4 times.
Mr. Chairman, I want to find out whether the nominee has ever been a subject of judicial misconduct.
Thank you, Honorable Chair. I have never been the subject of judicial misconduct. Thank you.
Mr. Chairman, in her CV, you see that she's been very strong on ADR and has chaired even the commercial court. And like the question earlier asked of her, the in the commercial court, and she alluded to the fact that this was very useful and was of the view that if this could even be extended to all civil cases, she believes that it could help. I hope that's what I heard you say. Madam, you know that when you opt for the ADR, you lose your right to appeal. Don't you think that it is one of the reasons that is maybe not encouraging a lot of clients to opt for the ADR from the practice experience?
Thank you, Honorable Chair. The answer is yes and no. Yes, because there are people who feel that the opportunity to appeal is one of the advantages of litigation. I beg to differ. I think the fact that agreements reached between parties at the end of the process in ADR is not appealable. It's one of the advantages of ADR, because with ADR, unlike litigation where the parties are like in a battle with the referee being the judge, with ADR it's the parties themselves who sit down and through compromise come to an agreement. And therefore, if you have sat down with a party and have reached an agreement that is acceptable to both of you, that should bring the dispute to an end or bring finality to the dispute. And so for me, that is one of the beauty of ADR. Thank you.
Mr. Chairman, earlier I heard to suggest that we needed to do some on some of the benefits of the ADR. Will she suggest or will she canvass for these pre-trial conferences in both civil and commercial, knowing very well that with that you still have the right to say, no, I don't want it, and therefore I want the full trial to go, and therefore the right to appeal, so that we have a starting point where people begin to see the dividend of the engagement outside the courtroom by engaging each other in that conference. Then we can then build on to be able to get to the ADR as one of the easily acceptable method by our court.
Thank you, Honorable Chair. I believe that ADR, with all due respect, is not an invention.
it is an international principle, and therefore we have principles that apply all over the world. And one of them is the fact that agreements, to a large extent, are not appealable. But we have court-connected ADR, so if you bring the case to a court, you are given the opportunity to settle. If you do settle, then definitely the ADR principles will come to play. If you do not settle, then you go on with the litigation, or aspects that are not settled by ADR go for trial, and those are appealable. Thank you.
Mr. Chairman, earlier in answering the question about packed court, I heard you say that you don't think the courts are packed, and you also don't believe that we are going to have 18 judges, because you believe that it is simply a replacement of vacant positions. Did I hear you say that?
Thank you, Honorable Judge. I said, to a large extent, nominations are made to replace retiring judges, and as far as I know, currently there are judges who have retired, and therefore the number has reduced from 15. Thank you.
Mr. Chair, Madam have served on the bench since 2003, and I want to believe that she is very familiar with the composition of our Supreme Court over this period. Do you recollect at any point before 2020 where our bench had to go beyond 14 members?
Honorable Chairman, unfortunately I do not recollect.
But I want to find out whether you are aware that by 30th of May 2020, the judges that we have on our bench were 19.
Honorable Chair, as I said, I do not recollect. And my statement was that generally nominations are made to replace retiring judges. Thank you.
Are you aware we currently have 14 members on the bench?
Thank you, Honorable Chair. I am aware we have 14. I am also aware that out of the 14, 2 have retired this year. Thank you.
Madam, let me show you the members of the bench. You have the Chief Justice himself, Justice Enimi Abua. You have His Lordship, Justice Jose Jones Doche. You have Justice Paul Bafuboni. You have Justice Gabriel Pauman. You have Her Ladyship, Justice Agnes Dozie. You have Justice Nane Amaye Nane Abaye Teye Ofue Amegati. I'm not a Ghana, so forgive me. We have Justice Professor Ni Ashi Kwete. We have Her Lordship Justice Maria Mausu. We have Her Ladyship Justice Avril Lawrence Johnson, Justice Gertrude Tokonu, Justice Clement Honuni Nuga, Justice Isufu Moro Tanko, and Justice Henrietta Abuna Nyako Mensa Bunsu, and finally Justice Emmanuel Yoni Kolendi. And Madam, these are 14 justices who are sitting on a bench. So no 2 have retired to require replacement. Unless if you are going to tell me that you know any of those that I've mentioned, that you know the persons on retirement.
Thank you, Honorable Chair. To the best of my knowledge, Justice Agnes Doji has retired. Justice Hoyonuga is retiring this year. Thank you.
I'm happy you said he's retiring. Well, you know,
compliance with Article 1454, he's been given extension. And unless you are telling me that whilst the extension lingers, when there's a matter before the court, he cannot sit.
Thank you, Honorable Chair. As far as I know, we retire at a certain age, and that is what is determined as retirement. The Constitution allows an extension for 6 months for stated reasons, but the retirement age still remains at 70. Thank you.
So that was what I was just finding out from you, that whilst the extension lingers and you are asked to count the members on the bench, do you exclude that person or you include that person?
Thank you, Honorable Chair. I would exclude that person. Thank you.
Now, earlier when you were asked, it's just related, when you were asked about the UK Independent Judicial Appointment Commission, I heard you say, I personally don't see anything wrong with what we currently have. Did I hear you say that?
Honorable Chair, I did say that I did not see anything wrong with what we have currently. But I believe I have also said that society is dynamic. So if at any point in time we feel that there's a need to change any law, I think what we need to do is to have dispassionate conversations between the stakeholders. Thank you.
Mr. Chair, your CV points to the fact that you've been at the appeals court since 2012. Is that right?
Honorable Chair, yes, that is so.
And between 2012 and today, there have been so many judges that came to the appeals court, did not spend a quarter of the time that you spend, and they move ahead to be at the Supreme Court. Am I right?
That is possible, Honorable Chair.
I'm not talking about the possibility. Because you were at the appeals court, you should know that as a matter of fact, that there are members who joined the appeals court, came to meet you. Some, they have not even done a quarter of the time that you have done, and are proceeded to be at the Supreme Court. Is it not a fact?
Honorable Chair, that is a fact.
You think a system where some can stay at the appeals court for over a decade, where others come and spend 9 months and move to Supreme Court, is a system that you will not have a problem with?
Honorable Chair, I believe that the Constitution stipulates the qualification for each level of the judiciary, and therefore, as long as those provisions are satisfied, I cannot say anything against it. Thank you.
Well, Mr. Chair, let me refer Madam to the same Constitution, Article 296. Yes. Where in this Constitution or in any other law discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of that discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And C, where the person or authority is not a judge or other judicial officer, there shall be published by instrument or statutory instrument regulations that are not inconsistent with the provision of this constitution or that other law to govern the exercise of these discretionary powers. Madam, you are very much aware that if a discretionary power is to be used and someone can be on the bench at the appeals court like yourself since 2012, staying for 10 years, others come 9 months and then they get hipped into this, the Supreme Court, and you sit with all the greatest respect and all humility, madam, and say that you do not see anything wrong with it. It gives me worry that if you get to the Supreme Court and you see injustice done, you will not feel worried about it, unless you are going to prove me wrong.
Thank you, Honorable Chair. Honorable Member, if I see something wrong about anything that goes against a law or the Constitution, I will speak against it. As I have indicated, the provisions in the Constitution provide the qualification for each level of the judiciary. And therefore, in my view, as long as there is no breach of the constitutional provisions, that is where I'm coming from if I say that.
Can I get some clarification? The honourable member's question is based on exercise of discretion. Is appointment to the Supreme Court an exercise of discretion or a constitutional is bound by the Constitution?
It is a combination of both. It is a combination of both because even though the Constitution provides the qualification as to when and who is discretionary, but then again, if anybody feels that there's an abuse of discretion, there are avenues for redress. Thank you.
So, Mr. Chair, just to move away from there, but just around the same subject. In 2016, the Ghana Bar Association and others versus the Attorney General, Ghana Supreme Court case 43. This is what Justice Atuguba said. Within the plaintiff, quote, and I quote, within the plaintiff's, before the quote, it says that the plaintiff had challenged the appointments made by President John Mahama to the Supreme Court, and the renowned Atuguba, Chief Justice of the Supreme Court, then as he was, had this to say, and I quote, "It is quite clear that there is here contemporary exposition where under the number of the Supreme Court justices has never exceeded 14, and a radical departure from this situation is therefore not within contemplation," unquote. I want to find out from you, this quote and that ruling by Justice Atuguba, do you think is a judgment that is reasonable to stand by even today?
Thank you, Honorable Chair. Honorable Member, I do not have all the facts of the case, so I'm not in the position to say what went into the factors that were considered in arriving at that conclusion. Thank you.
Okay, so in this relation to that, Madam, have you in any way looked at the Constitutional Review Committee's report in relation to the judiciary?
Yes, I have. I have read.
Did you see the suggestion they made with regards to capping the Supreme Court?
Yes, I did. I saw that. But I think if my memory serves me right, in indication that there should be stakeholder consultation, because I know that in countries where they have a cap on the Supreme Court, they also have accompanying flexible mechanisms. It is not rigid, so that if for any reason there may be the need to increase, that avenue is available. Thank you.
And you know the suggested number they were talking about is 15.
So,
now we are a country that is having a huge challenge with our economy. And you know that each Supreme Court justice retire on his working condition, salary and everything. You think that it is time, it's around this time, even if I take your argument that Sonunuga cannot be counted, where we have 13, where the Constitution itself has stipulated that it should be the Chief Justice and not less than 9. That means we have at least the minimum the Constitution has said. That is it the time for us to be adding 4 more Supreme Court justices to our bench?
thank you, Mr. Chair. Taking in view the workload as I have referred to earlier, and as I stated earlier, the numbers in my view are not too high. But I also agree with you that we should look at the implications and maybe have conversation and balance it, because it is a constitutional right of every citizen to go to the commercial court, and we cannot deny people that. And therefore, I think we should have stakeholder conversations, and as I said, dispassionately, balancing the financial implications with the need to exercise the jurisdictions. Thank you.
I just want to now veer into what we just mentioned earlier, the Article 1454, that has to do with Justice Onunuga's extension. You have Article 1454 of the Constitution. Mr. Chairman, with your permission, I read. Notwithstanding that, he's talking about the Justice of the Supreme Court. Notwithstanding that he has attained the age at which he is required by this article to vacate his office, a person holding the office as a Justice of a Superior Court or Chair of the Regional Tribunal may continue in office for a period not exceeding 6 months after attaining that age, as may be necessary to enable him to deliver judgment or to do any other thing in relation to proceedings that were commenced before him previous to his attaining that age. Madam, I know you are going to the Supreme Court. Does this warrant that to still be taking witnesses? Is it not restricting as to when you are giving judgment, or there are some few processes that will help you finish the case before you leave? Does this warrant that the judge can be taking fresh witnesses and hearing those and making all those arguments?
Thank you, Honorable Chair. Honorable Member, I do not believe that I have the power or the mandate to sit here and speak for the Chief Justice. This is a discretion that has been given to the Chief Justice. I do not have anything to say about it. Thank you.
Well, but Mr. Chairman, so earlier you were asked about the perception of the bench, the court, the Supreme Court in particular. Don't you think that matters such as this further exacerbate the situation where there's some perception that justice may not be done? When you know, just like any other citizen, know that justice should not only be done, it should be seen to manifestly be done. Don't you think that cases like this further exacerbate the perception, the wrong perception about the judiciary?
Thank you, Mr. Chair. With all due respect, I think we are preempting the situation. We do not know. You are making a reference to a specific judge handling a specific case. We do not know the outcome of the case. So for now, it's just perception.
Mr. Chair, I just want to find out from Madam, having moved from the High Court to the Appeals Court, and if by the grace of God,
Parliament approves of your nomination, you are going to be at the Supreme Court, whether our judiciary and the system where we run, you have an appeals court sitting as an additional High Court judge. The judge moves to Supreme Court, still continue to sit as an additional High Court judge. It's not also fueling the perception that some reason, for one reason or the other, there's some motivation to allow one judge to handle a case all the way from High Court to Appeals Court to Supreme Court, that there may be some political reasons behind it.
Thank you, Honorable Chair. Any and everything can give rise to perception. But again, the Constitution has given that discretion to the Chief Justice. And there are times when probably a judge may have some special expertise in an area and therefore will be asked to sit as an additional court. I do not know everything that goes into that decision. Thank you.
Last but not the least, Mr. Chairman. Earlier, Madam was comparing the U.S. and Ghana, where she said that the U.S. Supreme Court will not handle more than 700 cases a year. Is that what I heard? 70, sorry. 70 in a year. I thought that's what I heard you say.
Yes, Honorable Member. That's what I said.
Mr. Chair, Madam is equally aware that because of the federal nature of the United States of America, every state has a Supreme Court. And therefore, they manage a lot of cases in the states. And each state behaves like a country. And to even be, maybe to be more precise, California as a state is the sixth largest economy standing alone outside the U.S., meaning that it's like a country. So they have Supreme Court within those states. So if you compare what pertains in the United States and Ghana, you may be comparing two different things. Don't you think the comparison between the two may not be absolutely right?
Thank you, Mr. Chair. I do agree with you, but I was making that point regarding the fact that it is not every case that is heard by the Supreme Court of the United States as of right. That was the point that I was trying to make. And that regarding the 70 cases heard a year, over 700,000 cases had been filed. They only had 70. That was the point that I was trying to make. Thank you.
The chairman, the last, when she was talking about the Afro barometer, and she said every person within the judiciary is lumped together, and the judgment is made on all of them, like without segregating the judges and probably the others. It's not a very fair assessment of the judiciary. Is that the impression that I got? Am I right? That's the impression that I got.
Thank you, Mr. Chair. Yes, to an extent. What I said was that we are all bunched together as the judiciary, not only judicial officers, but even investigators and other stakeholders. That was the point that I was trying to make.
You know that when they talk about this, just as they talk about the judiciary, when they talk about the politicians, it starts from our serial callers. So, in that case, the politicians will also be arguing that, segregate politicians who are ministers from those who are parliamentarians, from those who are serial callers, or foot soldiers for that matter. But that is the challenge that we have with the system. Maybe we just need to encourage them, maybe instead of disagreeing with them, but try to find out how they can improve what they are doing. I wish you well. I pray that you serve our country when the opportunity comes and you are on the bench.
Thank you.
Yes, ranking member. Chairman, thank you very much. Since the nominee, Her Ladyship Barbara Francis Akayesu, is naturally progressing from the Court of Appeal to the Supreme Court, I intend to use this last leg to wax your mind on constitutional interpretation. I know that when the Honorable Sohine took you to the realm of economics, you were first to say that that was not your baby. May I with respect refer you to Article 36 of the 1992 Constitution, and to take you back to what the Honorable Sohine, now you will be asked as a Justice of the Supreme Court to interpret Article 36 tomorrow. And it reads, that states shall take all necessary action to ensure that the national economy is managed. So the economy is being managed. Related to his question, and I go further. Such a manner as to maximize the rate of economic development, and these are my emphasis, to secure the maximum welfare, freedom, and happiness of every person in Ghana. Is the economy being managed in a way today that we are securing happiness for Ghanaians? Thank you.
Thank you, Honorable Chair. I believe that the section that Honorable read forms part of the directive principles of state policy. And we all know that these are to guide all the three arms of government, the executive, legislature, and the judiciary. Thank you.
Are Ghanaians happy? Are you happy with how much you are paying for fuel and for electricity in Ghana in accordance with Article 36 of the Constitution, my Lord?
If you wish to comment on that, you may, but it's not a question that is admitted for your consideration.
Chairman, I'll come to her judicial oath. If you have your constitution with you, may I with respect refer you to the judicial oath. And I'm particular about the sixth line from the constitution that I'm holding. It reads, no, judicial oath, page 206. I will truly and faithfully perform the functions of my office without fear or favor, affection or ill will, and that I would at all times uphold, preserve, protect, and defend the Constitution and the laws of the Republic of Ghana. What these words, what's their meaning to you?
Thank you, Honorable Chair. These are very deep words, and they mean a lot to me. And sworn to this oath. I abide by them in every case that comes before me. Thank you.
Thank you very much, Chairman. And one of the major issues in Ghana today, my Lord, is gifts. Gifts. And I've always paraphrased Olusegun Obasanjo of Nigeria. Gifts meant to corrupt, and gifts in the true sense of a cultural gift in the Ghanaian sense. We've seen at Christmas, as was reported by the Anas expose, goats and sheep being given out as gifts, some of it not even reported as required of the Constitution. Obasanjo says that the value of the gifts sometimes determine whether it's meant to be used to corrupt or not. When he uses the word token, if the gift is weightier than a token, then it meant to elucidate a certain compromise. What, in your view, can we do as a country to deal with the phenomenon of gifts and its capacity to compromise the delivery of public goods and services? Thank you.
Thank you, Honorable Chair. If I heard you right, Honorable Member, you referred to different types of gifts. Since I am here as a judicial officer, if I may be permitted to speak as a judicial officer and speak for myself, I will not accept gifts from parties or lawyers that appear before me. I will accept gifts from family, friends, and our code of ethics, a code of conduct allows us to do that. Maybe the society needs more education to the effect that you do not have to give a gift to a judge for your case to be heard. Maybe that is the kind of education that we need. Thank you.
Thank you very much. And you are aware that when you take gifts, it should be reported in accordance with established laws of Ghana. Do you share that view?
Thank you, Honorable Chair. I have an inkling about that, but I believe I'm not exactly the nature of gifts that you have to declare. Thank you.
Chairman, thank you very much for your indulgence. May I now take you to Article 38, even though non-justiciable, but I want you to explain to us why you think the framers of the Constitution made a distinction between Article 38.2 and in particular 38.3. And Chairman, with your indulgence, I quote, is on the state shall provide educational facilities at all levels and in all the regions of Ghana, and shall to the greatest extent feasible make these facilities available to all citizens. Now, you would be interpreting this Constitution, whether justiciable or non-justiciable. I want to get your view on it. Article 38.2 provides the government shall within 2 years after Parliament meets after the coming into force of this Constitution, draw up a program for implementation within the following 10 years. Get the words there. For the provision of free, compulsory, and universal basic education. Those were the words of the Constitution. In 38.3, the wording reads, the state shall, subject to the availability of resources, subject to the availability of resources, provide equal and balanced access to secondary and other appropriate pre-university education. Why I raise this? Do you see a difference between 138.2 and 38.3 if you were to interpret the Constitution? Thank you, Chair.
Thank you, Honorable Chair. I believe from the provisions that you have referred to, one talks about the availability of resources. One does not make any such reference. But as we all know, these are part of the directive principles of state policy, and there's a debate as to whether they are justiciable or not. Thank you.
Like your cautious approach, but I'm still there. Now, I take you to Article 187. Chairman, with your indulgence, the Auditor General, and I mean Auditor General, I'm referring to the institution, have done pretty well for our country in exposing maladministration, misappropriation, embezzlement. Every other year we hear reports of monies being missing. Public officers appear before Parliament's Public Accounts Committee, mixed exposure to many of it. Now, if you read Article 1876, and I want your view on it, whether or not the Auditor General can proceed further to do some of the things he's doing, or he ought to wait for Parliament. By your understanding of Article 187, it reads, and I provide, Chair, Parliament shall debate the report of the Auditor General and appoint where necessary in the public interest a committee to deal with any matters arising from it. Where Parliament has not exercised this, what do you think the Auditor General can do or cannot do? I thank you, Chair.
Thank you, Mr. Chair. Mr. Chair, to adequately answer this question, I will need to really study the provision, which I have not as yet done.
Okay, you are going to Supreme Court, so get ready.
Yeah.
I'm sure somebody probably will meet you along the line. Oh, I've taken the win out of Chairman's cell. But still on constitutional interpretation. Article 1815, what's your understanding of it? 1815. We've seen the Supreme Court, you've done some ruling, you've given judgment on Osofotone and many others. With Osofotone, Chairman, accepted. And then you still see ministers avoiding the Attorney General, they go and enter into questionable contracts in the name of the Republic of Ghana and subject this country to needless judgment debt. What, in your understanding, does Article 181 provide? It reads, and I quote, 1815, this article shall, with the necessary modifications by Parliament, apply to an international business or economic transaction to which the government is a party, or it applies to a loan. Constitutional interpretation, your new duty as you go to the Supreme Court, what will be your understanding of this provision? Thank you.
Thank you, Honorable Chair. I do not think that this provision needs any further interpretation. There's no ambiguity.
So, at least, Chairman, you have assured me that she knows the rule against ambiguity. And that you only go for meaning of words when their first meaning leads to absurdity. On authority, I respect that. Now that brings me home, back to the judiciary. What will you do to inspire confidence and faith in the winning integrity of the judiciary as an individual? Thank you.
Thank you, Mr. Chair. When I was asked the question what the mark of a good judge was, I listed a number of things and then ended by saying that for me, what I cherish most are integrity, fairness, and I added reticence. So that is what I'll stick to those qualities.
You won't shift and you won't add to it.
Hard work and courage.
Chairman, should the nominee get approved, she is a probable candidate for Chief Justice because the Constitution says that the President can at any time, once you get to the Supreme Court, you have 2.5 years. We are aware that the Chief Justice is going. The President can exercise. He's retiring. Thanks for that. He's retiring shortly. Probably he doesn't have more than 2 years. That's the understanding I have. Next year. So you are a probable candidate for Chief Justice should this committee qualify you in Parliament. So when the Honorable Muntaka was asking about exercise of judicial discretion, whether merged in constitutionalism or not, he wants you to speak as a probable Chief Justice. Will you ensure balance in appointment and promotion to the bench? Thank you, Chair.
Thank you, Mr. Chair. In the unlikely that I am made Chief Justice, yes, I will abide by all these that we have said. Thank you. And the likely, unlikely.
There's a ruling of the Supreme Court that undermines the constitutional injunction not to have persons above 16 years regular appointment in the public service. You know, for those of you in the judiciary, you are respected. So we say because of your wisdom and knowledge, you can spend up to 70 years, particularly where you are going. In others, the Constitution said 60. Why are we encouraging persons still being in regular public service when the Constitution frowns upon it? Thank you.
Thank you, Mr. Honorable Chair. Honorable Deputy Chair, should I understand you to be saying that there are people over 60 who are still in employment?
Chairman, she can answer your question.
I'm seeking some clarification.
Clarify your question. Clarification.
Yes, please.
I'm saying that persons who ought to be home must be home and not be allowed to extend their tenure in public service because of some ambiguity in a ruling by the Supreme Court. Do you share that view?
Honorable Chair, I would say yes under normal circumstances, but I do not know the circumstances of the case that you are referring to. Thank you.
Chairman, we haven't given her the opportunity to walk around since she came, so I should be landing now to allow for those other natural events. But the Honorable Muntaka and earlier one of our colleagues, and Chairman, I'm ending. Let's go to 128 of the 1992 Constitution again. 128. And I'm interested in 1281 and 2. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. So a minimum threshold is provided of 9 plus the Chief Justice. Now it reads in 2, the Supreme Court shall be duly considered for its work by not less than 5 Supreme Court justices, except as otherwise provided in Article 133 of this Constitution. Also provided. So threshold 9 to 10, a minimum of 5. The Supreme Court again is vested with the review jurisdiction. Review jurisdiction say you can expand the numbers. So to his numbers, you have 5, you have 9, you have 13. Why do you think that we should go beyond 14?
Thank you, Honorable Chair. Apart from the workload and the issue of cases going to the Supreme Court automatically, there is also the phenomenon of recusals. We know that in our system, because of the way our society works with all the interrelations and things, the incidence of recusal is very high in Ghana, unlike in other jurisdictions. So, for instance, I know that in the United States, if there is a matter and a judge has an interest in it, all he has to do is state his interest in open court, and that is all that it takes. But you cannot do that in Ghana. So these are some of the reasons why we need the numbers. Thank you.
Chairman, with this answer, ending whilst wishing you well, but with advice to Chairman to the President Akufo-Addo, that he shouldn't exceed 14 at all times. He should endeavor to stay within what he inherited from 2000 through 2008. We've not had instances where the number of justices of Supreme Court are expanded to 18 and 19, only under his watch. With this, Parliament must sit up and make sure that we check him and check him well. Chairman, with that, my last question on separation of powers.
I will respond to you.
It's Patrick. I've only sent you, Chairman, on our behalf, that the President, and we are serving notice as a minority, that if he so wants to expand it for political expediency, we'll hold him to check. He must stay within these reasonable numbers for now. We have no problem with your kind of numbers, but beyond 14 and 15. So, Chairman, for the record, the Supreme Court has never been more than 14. I've checked, yes, I've checked. The statement that it was 19 is not factual. Now, members are retiring. So, new proposals are that they will retire and they will return to 14. So, it would have never been more than 14. But thank you for the suggestion. I will communicate that we will stay, and I'm convinced that we will stay within 14. Very well. Honorable me. We will discuss that at our colloquium. I'll check. I'll give you the record as at me. Very well. I'm also a member of Parliament. I'm also a member of Parliament, and I'm entitled to have my own views. Yes. I have only one question. The Honorable Ranking Member asked a part of it. Dealing with the Auditor General, says that his recommendations will come to Parliament. Parliament will debate, and Parliament may take further steps. So, if the Auditor General finds it necessary to surcharge or ask that some people make some refunds, is that not part of the recommendations to the House, or is that final, as appears to be the interpretation?
Yeah, thank you, Honorable Chair. I believe that the recommendations as made by the Auditor General to the House should be seen as final, unless, for whatever reason, somebody has a problem with it and would then go to court for an interpretation of the. Thank you.
In fact, at the Public Accounts Committee, many of their findings have been found not to be supported by either the law or the facts. So their recommendations are recommendations to Parliament, and when Parliament reviews them and finds them satisfactory, that is only a comment. It's not intended to be a question, but the general view appears to be that because the Auditor General says so, it is so. But when they appear before the Public Accounts Committee, many have been found not to be either supported by the law or the facts, and the recommendations are therefore reviewed, and they themselves, in their presence, the Auditor General, in their presence, they have accepted that their recommendations are not either supported by the law or the facts. But on that note, thank you for attending. We will discharge you now. You will hear from us later. Congratulations once again on your nomination.
Thank you for having me. Thank you.
2022 Basic Education Certificate Examination began today, Monday, October 17th. We are here at Accra Academy, one of the centers for the examination, to interact with the teachers, students and supervisors on how the process is going so far. I'm Ishmael Batoma.
The social studies paper was okay. It was manageable. We are just hoping for the best. At first, there was a little fear in me, but it's just like a normal paper you're writing, like the mocks we used to write. So it's okay. I'm hoping for the best. I'm just hoping to get good grades because I know what I've written. I know I'm doing well.
I was very scared before entering the examination hall, but when I entered the hall, I was confident and I was able to write the exam. The paper was normal. The social studies, I'm expecting 1 or 2.
We wrote social studies today. The paper was cool and manageable. I'm expecting 09.
It was okay. It was nice. No, there was no fear. They weren't that strict on us. It was okay.
It was really cool. I was really nervous, but when immediately we started the paper, everything was going cool.
How do you feel after writing your first paper?
Really okay.
It was good. It was better than our mock. It was easier. When I saw the paper, I was scared. When I entered the hall, I was scared, but when I started to write, I felt better, especially with the objectives. So I'll be expecting 1 in all.
We read social studies.
How did it go?
Well, it was nice, but it seems like all that we learned and what we revised previously were what came. So it was quite good. Breath release. I'm okay.
Social studies. The written part, that's the session B. A. Second.
So how did it go?
Oh, it's cool. It's not that scary.
I said it went well. The questions were good. I said the questions were good.
Okay, so you are well prepared.
Yes. It was cool. It feels good.
So far, based on the interaction with the kids after the exams, I can see they are happy, meaning what they were expecting actually came. And looking or going through the questions, I have seen all what we taught them. Everything, almost 90% is in. So I'm glad.
They were adequately prepared for it.
Sure. They were fully prepared, and based on their reaction, I can see everything is going on.
So far, so good. We prepared our children adequately for this year's BECE exams. Today being their first time of writing an external exam, we encouraged them and told them not to panic, and they abided by that. And then when they came out, they said it was okay. I believe because we covered a lot during preparation, that made them to have it on the easier side. Apart from that, also we could see we have a prepared lunch for them, so that they don't go far to go and buy food and come and, at the start of the next paper, then they will not be, we will be looking for them, and that also makes them stay organized.
As we all know, today we are starting the BECE examination, and in fact we were here on time because we were told to report on time so that we can at least have a feel of the environment before the start of the paper. Actually, we haven't encountered any challenges so far. The paper came very on time, and so far so good. First paper, my students have gone and they are back with a smiling face. So I think everything went well, and we are praying and hoping that the subsequent papers that they'll be writing will also go well. In all, we give thanks to God.
So far so good here at the Accra Academy BECE Center. The first paper, Social Studies, has ended, and from my interactions with the students, the paper went really well. Even though they started nervously, they settled down and wrote their papers well. The teachers are also telling us that the students gave them good feedback as to how the paper went. They are prepping them for the next paper, which is ICT. Reporting for GhanaWeb, Ishmael Batoma.
After gaining prominence with Money, First Sermon, Second Sermon, Koku the Traveler, and then Soldier, Black Sherif has released his debut album, The Villain I Never Was. And so we are seated to have a conversation on that. I am Benefo Boaben Abrantipa, and this is E-Forum on GhanaWeb TV. Thanks for joining us and joining me on this episode. I have Way Otin. Way Otin is a music producer, a sound engineer, very renowned and revered personality in the arts and entertainment industry. Otin, welcome.
Thank you, my brother.
You see, the first time I heard of his name, I thought I didn't know it was coined from your real name, DJ Ashman. Saba Pawe, and you be we are singing Kofone yo Modiano crowd. They don't have our non-kwa or Ashman. Yeah. Thanks for joining us.
Thank you, bro.
And then he's a fan of Black Sherif and the host of Friday debates or sports debates on GhanaWeb TV. Joel Ishon, thanks for joining us. One person I admire most in the industry. It's the second time I've met him. The first time we met at Kwesi Athers album launch and listening. Maybe if you're a show near man. Aha. No, to me, if you're already be family, no, the kofa or no say him. Who say yeah. Olele Salvador. Sally, thanks for joining us.
Thanks for having me.
Now, Olele no Richard Kingston, the Nibiana. What's your industry?
I used to actually keep in school.
Okay.
That was how I actually got it, because I'm a goalkeeper in school. So
okay.
Well, they thought I was that good enough to be called goalkeeper. But now I keep the culture.
Okay, that's nice. Welcome, gentlemen, to the studio. So let's begin the conversation quickly. What would be your initial comments on the Black Sherif album? What's in?
I think Black Sherif, a great guy, a newbie who is trying to carve a niche for himself. I always say his first album is his 20 years life being put together. So this is a test line for him to showcase and exhibit what he has experienced over the years. And I call this his personal album because everything is about him. Yeah, everything is about him. He spoke about himself from A to Z. His experiences, what he's gone through, his feeling, what he possessed, the energy, the feeling, everything, it's all about him. So I would say this is the Black Sherif album, something for himself. But I also believe that everybody who has similar situations can also relate. If you feel you're blessed, if you feel there's an anointing on you, there's an oil on you, you can relate. If you feel you've lost somebody, you can relate. If you feel snitches shouldn't come around you, you can relate. Wherever you find yourself, if you want to be part of that album based on your experience, if you share something together, I believe you can also relate. So this is an album for him, but we as a people, it's something made for the industry. So we always see where we also can relate, enjoy, and push, a young visionary to become a household name, because obviously the music industry in Ghana need more at the top than just one top. So
let's settle on the concept of the album and then the artwork, the cover art. Is it what you expected, or you think it could be better? Let me ask Olele on this.
Thank you. So for me, pretty much, we've seen the kind of person Black Sherif is. If you see the kind of pictures he takes and the kind of fashion he's involved in, a bit quirky, not too conventional. Many have argued that if it was Kwame Eugene who was dressing that way, there would be chaos in the space. But I think it's not really loud out there because Black Sherif has been able to own that kind of style. So it fits him, it suits him, and the kind of music he's done lets you know that he's a misfit. right from the onset, you know that this guy is not here to be a part of where we want to put him. He wants to set his own pace and run his own race. And so I wasn't too surprised when I saw promotional pictures that led to the final artwork. And if you look at the artwork, it looks like, I don't know how to explain this in the, I can't find the words to explain it, but I think it's more of an artist that feels like he's lonely, you know, even though he's achieving all those things that he's been able to achieve. And you look at the reverence and lighting of the artwork, it's like there's so much noise, there's so much, you know, pandemonium out there. People are literally cheering on and everything, but within himself, when the lights go dim, it's just him alone as Kwaku Frimpong in there. And this is the same Kwaku Frimpong that has been chastised, lambasted, you know, all sort of things have been said about him. And to go with the album title, The Villain I Never Was, matches that kind of art direction they were able to achieve with the artwork. But for me, if you ask me, I know that there's a lot of people who like to focus on the artwork. I feel like the artwork is just supposed to add to the aesthetics of your project or your album. But for me, what I was looking forward to is the content of the project. And I don't really like to place a lot of emphasis on the fact that, because you can have a great artwork and the quality or the content is nothing to talk about. So I just sit down and I look at the artwork as though he had a good team that sat down together. I'm sure David Nikose and the rest of the team at Park Studios were all part of the direction, and they were able to bring out that kind of artistic side of Black Sheriff. So all things being equal, unless the art directors come and tell us why they shot the way, because you don't want to misinterpret, you know, you can only guess, but you can't really misinterpret what the art director is responsible for the direction, you know, in terms of the album art.
Ashman, you agree with that?
Oh yeah, to a larger extent I agree. You know, Black Sheriff, from the first single that he drops, the attitude he came with, we all use a guitar and a knife and and everybody was talking about it, but all of a sudden, like I said, he became calm, trying to send a certain message across. So per the artwork and all that, I agree with that one.
The songs on the album, which, I mean, he has said that is the album is his autobiography. Which of the songs would you say you gravitate towards the most?
Well, the Konongo Zongo song.
Okay.
Yeah, I like Konongo Zongo. You know, I see this Black Sheriff album like Bradford's Paimuka. You know, when Paimuka came, that was 99. The youths then, you know, we all jumped to the song. Though it wasn't the club banger where we were playing it in the club, bang, bang, though Yanum was there. But most of the songs were like in the car music. And you just nod your head to the sound. This album have the same feel. If you check most of the songs, from the beats, though the beat is not the same, but you find similarities in the songs. And the message is trying to send across. I know Bradford's manager is here.
Yeah.
You will not
when you mention it, I was about to say Bradford's
manager is here, but I'm taking my mind back to 22 years, 23 years ago when Yanum came out. The feel. Some people were like, Bradford. And you mean, what's this? It took time. We understood what Bradford was trying to send across. The message is where he's tackling like the situation on the ground and about himself on that album. So with this Black Sheriff album, myself, I feel like that's how I see it. I like Konongo Zongo and the reggae song on the album. Basically, I like 2 songs on the album, apart from the one with Burna Boy. But the reggae, and I forgot the title, but Konongo Zongo, I go for Konongo Zongo.
The reggae could be either Toxic City or 45.
Yeah, I like those two. Oh, Paradise is not bad, but could be our Don't Forget Me. Don't Forget Me.
But Toxic City also has
a bit of a...
That song was he said that song was produced in the UK.
I think that would be
by London.
Okay.
By London.
That sound also has this island you know, Jamaican touch. When you listen to Toxicity, the way he sings on it, and that's why I feel like Oten said, it is an album that gives us the opportunity to appreciate Black Sherif as an artist. And I heard him on an interview with Apple Music where he says that the reason why he decided not to feature anybody was because this is his first project. He wants you to know him better. He wants you to know that when you put me in any genre, moving forward. So in the future, if anybody, because we see Burna Boy doing songs with the Assurance, we see Burna Boy doing songs with Madonna and the likes. I'm thinking, okay, this is Black Sherif's thoughts, that once upon a time, a big artist could come from anywhere in the world and say, I want to do a song with this guy because I've heard him do a song like this. Kid is blessed with Mavado. He tells us on the Twitter space that on his album, the Golden Boy album, I've forgotten the name of the song. It was a reggae song. Mavado heard that reggae song on that album and then reached out that he wants to do a song with him. So when an artist thinks like this with his first project, it gives you an idea of the journey he's on. Many people, like Ashmin said, I was in the 90s, I wasn't around when Paimuka came. So I mean, obviously we grew to listen to Paimuka. I wasn't around when Paimuka came, so I won't be able to tell you what the energies were like. But for Black Sherif, the reactions are mixed. Some say, oh, I'm already a Black Sherif is not giving us a Black Sherif we know him from first and second sermon. You know. But interestingly, after a few days, people are now coming back to say, you know what?
The songs are
actually good. Yeah. You get, because there are 14 songs. You can't obviously like every song on the album, you know. But at every point in time, and like DJ Asmin said, when you are driving and you put the album on shuffle, the kind of songs that, I don't know whether it's an algorithm thing, I don't know, but the kind of songs that play, it gives you the opportunity to reflect. Because everybody may have lost a loved one, everybody thinks like they are the prodigal son, you know, everybody thinks that they are the breadwinner. They need to. So there's a song in there for everybody. And that is what I want to big up the team for selecting the songs. I'm not too sure if the 14 songs were just the 14 songs. I'm sure there were other songs. But the team responsible for selecting the songs to help shape the image of Black Sherif for his first album, it's a big plus. In
his interview with NYDJ, he mentioned that O Paradisi was actually a song that there was contention over as to whether or not it has to be part of the album. But Otin, is it his reason for not featuring any artists on his maiden album?
He has Burna Boy on.
No, I mean apart from
so just say apart from.
So apart from Burna.
Yeah.
And that was actually a remix. So
still doesn't matter. It's on the album.
Yeah. Okay. You think it's a good one? That every artist who at a point or at the initial stage of their career gains prominence needs to imitate.
Okay, so there are twists to this. First of all, you need to know who you are. You need to know your backing to take certain decisions. If you are personally investing in yourself, my brother, you don't take chances. Whatever chance Black Sherif took, he took that chance knowing the kind of backing he has, and he knows it's not going to hurt him. You understand? But if you and your friend, your brother, some man who believed in you, some man your sister went to speak to come and invest in you, you realize that you do not have room to even make the slightest mistake. So you would go all out to make sure that you tap in every aspect of the industry or into a certain audience